Difficult person is also not well.
Tomorrow may not be.
Are called regularly to senior citizen to the police, and police is enforcing a agreement for sale.
Tomorrow you can take a chance.
If possible.
Tomorrow you can take a chance.
Pardon to mention, my lord. Casting of MDW, my lord. Casting of MDW. Tomorrow.
Beg interruption, my lord. On last occasion, your lordship directed to file an affidavit taking into the judgment passed by the Honorable Appeals Court in the case of Rajesh versus Neha. I have already filed the affidavit. Let the matter be adjudicated.
Maintenance. You have a husband.
I am from the petitioner. Yes, my lord.
You have a husband.
I am from the
What is the great hurry? You can wait for some time. Only monthly maintenance. We'll see.
As your lordship passed the direction, so I filed
Okay, solve. Okay.
the affidavit.
I'll just see how can it. Yes.
Pardon.
Give the memos. We'll see. We'll prioritize things. Okay.
Pardon to mention, Mother. I have already mentioned through Puri BC, that is CRLMC 3673 of 24 and CRREB 270 of 24. Parties are amicably settled the matter, that is compromise.
What are the offences?
Offences, one is under section 420, cheating matter, and another is 138 in Act.
138 compromise.
Again.
So 138 wala lage do. 220 wala. Same accused.
No, both are
Different
different
accused.
matter.
Different matters.
Again.
Okay. 130 wala lage do. And 420 wala dikhte.
Pardon to mention, my lord. My lord's petitioner has filed for crossing, my lord. And he has got information that next week this will be read, my lord. His my lord was pleased to pass the order.
How? DPC and this, because of this criminal case, he may not be.
Hampered, DPC consideration hampered. Instantly got information, DPC will be the next week.
Mayor filing a FIR will not hamper the DPC. Anyway, you give it.
May be taken in similar order, my lord, was filed in another case. Same event, another court, the case is already stayed, my lord, proceeding. So my lord, you have to take
We'll see. We'll just give it. Bring up. Yes, bring up.
Pardon, my lord. It is an urgent case. File CRLC state. And then you have to know one of the fees and then that on March. It's coming Wednesday. So it is a matrimonial dispute.
Matrimonial dispute. 498. Give.
Lordships.
We'll see. Yes.
Pardon to mention, your lordship, and VC.
Yes.
Your lordship, there is a case in which there is a specific direction to list this matter on 24/4/2023. Your lordship, this matter will become infructuous because there is no stay operating and the trial court is proceeding with the trial. Now, lordships, this case is Republic of India versus Ramchandra Hasda. And your lordships has also allowed the mentioning, your lordships. Your lordships had asked me to give the memo, but it is not listed.
What was asked in that matter?
Your lordship, 13(1)D PC Act, he was discharged. We had filed a revision application. But there was a particular direction by this court that the matter will be listed on 24/4/2023. And the court said that we'll dispose of the matter. But the trial court is continuing. If the trial will be over, your lordships, my petition will become infructuous, your lordships. Only a short point, your lordships.
Give a memo. We'll see. I'll try and adjust it. Huh?
Yes.
Next week I'll try.
Pardon to make mention, your lordship, my lord. My lord, in weekly list, my lord, item 103, my lord. As per your lordship's order, my lord, both the sides have filed a written note submission, my lord. Lordship, may kindly give a short date so we conclude the matter.
103. We'll see.
Yes, my lord. Yes, my lord.
103.
Already written note already filed, my lord.
If the miscellaneous matters are over by 3:30, then I'll pick up.
Yes,
Okay.
my lord. Grateful, my lord. Grateful. Much obliged, my lord.
I want to make a mention, your lordship.
I may be pardon. I am in.
That matter, Mr. Milan Kanungo, myself, we all have laws.
As a group
that
matter. Group matter.
Pattern matter.
Okay.
Yes.
Be ready,
Hello.
I will pick it up. If after 3 o'clock,
Part is over, they have also filed a written objection.
partly this is heard, it seems. Huh?
Yes.
Yes, my lord. Yes, my lord.
Yes.
I may be pardon to
Griffin.
I may be pardon to make a mention before lordship.
Yes.
Item 79, it was adjourned to 9/4, in fact. Anyway, it has come today, it may be taken up after, in the week of, first week of April, Your Lordship. 79.
79. Okay.
I am for the opposition.
Item 86, my lord, matter was compromised.
We'll call page wise so that it will be easier. Yes.
Item 1 to 4.
My lord, item number 4, there is a sub-item. That is nothing to do with this case, my lord. Last time your lordship has delisted it, but again it has come.
Did it come, your lordships?
It has
Hey,
not.
Item 4, I'm telling on behalf
Both the matters are different.
No. Yes, sub-item is totally different.
But your lordship,
So it is.
your lordships are tagged it because the point of law is the same, your lordship. Let the matter come, then your lordships can look
At
into
the
it.
point of law.
Yes.
Lord,
The point of law
Point
is
of law is changed.
My lord, not today, my lord. I have
No,
some
lordship.
difficulty.
I agree with my Lawrence Singh, item 4, sub item 1. I'm appearing on behalf of SK Dar.
I have some difficulty because my uncle is in hospital.
5-6
So
times. Your lordships 5-6 times they have already taken time. It can be decided
No.
in 2 minutes.
Mr. Naik, there is a personal difficulty. There is a
I have a difficulty.
When your
medical
lordship,
urgency.
lordship will take up the other matter, then this matter may be taken up some other day, your lordships.
No, sure, I'm appearing for the other matter.
Other matter he is
on behalf
asking.
of
See,
SK
there is a
Dar.
medical
We are
urgency
agenda
we
to-
should.
The other matter.
So let it be in the first week or second week of April.
Naik couldn't hear you. Therefore he is.
Hi.
Now,
First week or second week of April.
yes. First week.
Second week, your lordship. Second week of April.
Second week.
All
Second
right.
week.
Obliged.
Both the matters.
Because there is a medical urgency.
Yes.
Family.
Much obliged.
I know you couldn't hear.
I wanted to hear him, your lordship, sir.
Yes, you couldn't hear. Yes, I know. Yes.
Item 5 to 13.
Item
7 minutes. Item 7 minutes, I printed let it come weeks after because I need some document of file this in this.
On request. Are there?
Item 11. Item 11, madam. Adjourned to another.
Sorry?
Item 11.
11, okay. Adjourn. On request again.
Item 14 to 29.
Item 16.
Okay,
Can you adjourn to some other day?
16.
30 to 42.
Lordship, item 32. Lordship, item 32, seeking for a short order.
Okay, 32 on request, adjourn.
43 to 54. 55 to 57. 58, 66. 67 to 72. 73 to 83.
Item 75.
I have
some upfront difficulty in any other.
78, my lord.
75.
75.
Fine.
Okay, Mr. Mishra.
78.
Entry ordinary possible.
Entry vote to come.
78.
78?
My lord.
Yes,
After 1 week, my lord, any date fix.
on request, huh?
Item 76.
70?
76,
76, yeah?
3 weeks.
76 also, adjourn, on request, yes.
79, my lord, I had already mentioned, my lord.
Yes, 79.
79, I'm appearing for the petition.
There is a request from.
But I pray for a short date, my lord.
Yes.
84 to 91.
86, my lord, matter was compromised between the parties due to some difficulties in the net dates as well as the date given to the parties. There was different, for that reason they could not come to
What are the offenses?
506 3SST. Both have compromised due to some dispute between the son-in-law and father-in-law, other villagers. FIR was registered. Some of the villagers are not scheduled tribe. For that reason, SCST was added. And in the meantime, the matter was settled. They have
Simply urgent have to.
fix up a date next week, any day.
Yes.
Yes.
Okay,
Get the record.
yes.
92.
Pardon to mention one Belgium matter, my lord.
Yes.
Item 1.
May
Yes, sir.
the order of convenience and the intercriminal proceedings
is under challenge. But order of cognizance is under Annex 3 at page 36.
Yes. Page 36, sir.
37.
Yes.
37.
Yes.
Cognizance taken on 4/9/2017. That numbers were under section 364.
2017.
70.
4/9/2017.
Answer. 364.
Why have you come so late?
But, in the main.
After 8 years, you are coming.
80. The trial is of the year 2016.
So what is happening in the trial now?
Trial has not yet come.
This is appearance stage, madam. This is the instruction. This is at the appearance stage.
2017.
But, madam,
Appearance means you people must not be appearing. Therefore, nothing is moving. Not appearing, avoiding. Appearing.
Ma'am, the petitioner is not avoiding. The main ground for personality is my lord. While the petitioner moved an application for this, the informant whom I have included as opposite party number 2 in this case has had filed an affidavit stating therein that that I am the informant in Bodmark PS case number so and so, that one of the culprit who took me in a bolero told that we are men of Ishwar Rao, the present petitioner. Therefore, I have mentioned in my affair as Gundas of Ishwar Rao, but Ishwar Rao has no any involvement in this occurrence, that I have no complaint or allegation against Ishwar Rao, that I have got no objection if Ishwar Rao will be released on bail in this case, that I am swearing this affidavit.
It's for the purpose of bail, you got bail.
Yes.
My lord.
You got bail.
My lord.
What is his statement under 161?
161, that is, your lordship can see charge sheet, man. Charge sheet at page 19. At page 19, man. What it, man? Second paragraph.
Yes. Show me 161 statement of the same person who has given affidavit. What is his name?
Name of the informant is Bipin Kumar.
Bipin Kumar. Show me his 161 statement.
That is at page 23, man.
23.
23.
Yes.
मेरा नाम बिपिन कुमार.
No, 23.
23.
Yes, Bipin Kumar. Yes. When was it recorded?
मतलब
Date?
31/1/2016, man.
When the affidavit given?
3/10/2016. Sorry, man.
3/10.
2016.
So 3/10 he gave a statement before police.
Man.
And after 3 days, when the bail matter was heard, and he gave an affidavit. Then,
What has happened in this case?
and this affidavit was procured by you only to get bail. It is very apparent. Why this can't be a ground for quashing. Just ignore that. What else you tell me? What else?
The petitioner is there.
And even if Binod Kumar's statement is taken off the record, 161, there are other evidence which is implicating you.
But after investigation is over, the charge sheet which has been filed by the police.
Yes.
Correct that there is no prima facie case against the petitioner. My lord, I am reading.
Yes.
During course of investigation, the IO visited the spot, examined the complainant as well as witnesses, and recorded their statement under section 161.
Yes, see 161 statement of Rajinikanth Sahu. See the statement of Prashant Naik. Everybody has taken your name.
Being influenced by me.
That I can't at this stage. You come to the court after 8 years for the cognizance, and you want me to appreciate 161 statement and pass an order?
But my lord, Bipin Kumar is no more discharging his duty as HR is influenced by.
You are very late. Now you move application for discharge since charge has not yet been framed, according to you. If something you can get, you can get.
May I pray one thing?
Yes.
My lord, before.
You could successfully procure the bail. It's all right. Why get in affidavit? It's all right.
Ready and willing for compromise. Notice maybe.
See, he may do it. He may not do it. See, that's not the issue. Issue is how will you ignore the other statements? How will you ignore the other statements? Binod Kumar, you might have own or whatever. But the other witnesses?
They will come, my lord. They will come.
No.
Your lord.
I see. Then what I'll have to do is I'll have to call all the witnesses, and then I'll record their statement to contradict their 161. That can't be possible. You file an application. That's the best. Right. Petitioner is agreed by the order dated 4/9/2017, passed by learned 4/9. Where is that order? Passed by learned SDJ,
My lord.
and written
Jharsuguda.
SDJ Jharsuguda, whereby cognizance of offences punishable under section 364 capital A, 452, 341, 323, 294, 506, 120 BI to C has been taken against the petitioner. And counsel for the petitioner submits that although the cognizance has been taken on 4/9/2017, but neither the charge has been framed nor the trial charge has not yet been framed. He has relied upon an affidavit dated 7/10/2016, purported to have been given by Bipin Kumar, the informant, Bipin Kumar, the informant. On the strength of the said affidavit, the petitioner submits that the informant in the affidavit has categorically stated that by misunderstanding, he has taken the name of the petitioner. It appears that on the basis of the affidavit given by the informant, the petitioner has already been enlarged on bail. I have perused the statement of the other witnesses recorded under 161 CRPC and other materials before placed before this court. Other materials form part of the charge sheet. I'm not inclined to entertain this petition at the belated stage. However, regarding head to the fact that the charge has not yet been framed, the petitioner is at liberty to move appropriate applications for the trial court seeking discharge. If such application is made, same shall be considered on its own. Yes.
Item 2.
Yes. Yes.
Hello, I am for the petitioner. Last occasion, my lord and senior took time to file reply.
File?
Here, my lord. Here, my lord, someone has been issued by the special court. Without appearing, they are going on taking time. And
Lordship, may directly see the last order, Lord.
order, what is your prayer,
He
your lord?
wants to press the matter on merit, Lord.
Yes, yes.
No, as for the opposite party in front, release the matter. Only he sought adjournment. That's all.
That's it,
Now you tell me what is this matter is about?
Lord, the matter, my learned senior will please, my lord. We are not well versed, to be very frank, my lord.
I'll pass it over.
My lord, tomorrow or day, next week, my lord. He's not today.
Simply.
They have been taking time, my lord,
We have-
since last occasion, my lord,
Time
for filing reply.
You were making wrong submission.
No, my lord.
You go through the cell. My lord, here only someone has been issued. They are not appearing there.
No, it's on the last 4 occasions, your lordship may see the orders,
If
my lord.
someone is issued, why don't you go and appear?
In view of concern judgment, they can appear and go on board.
That is something which my senior has to. But I need to take instructions on that.
You can argue better.
No,
Don't worry.
I'll
You
leave
start,
that aspect to my
let us
senior.
see. If
No,
anything
I'll
happens,
leave
then
that
I'll attend.
aspect to my senior, my lord. I'm not well versed, but I'll be very frank, my lord. That way, because on the
counter to also.
Okay, Mr. Agarwal, file the counter to the petition and supplies the
Copies are below.
copy of the
In both matters.
supply letter to the both matters and lease the matter for hearing first week of first week, second week.
my lord says
Fixed date. I am giving fixed date.
My lord,
Okay. You just see if the same thing you can utilize that.
That is.
Better I'll dispose it up. Go then.
Here another, an idea has been filed, my lord, for stay of order passed by the adjudicating authority.
That your lordship has been protected by the last order, my lord. I'll only pray that.
Not protected, because only order was not, he will file an application before special court, he will adjourn the matter.
What is happening is once the PMLA proceeding starts,
Yes.
from the date of filing 44 complaint, the accused persons are approaching the court, 482 court.
Yes.
For every step.
Yes, my lord, because
Summoning stage, filing
predicate
stage.
offenses.
Where is
Because in
now,
predicate offenses, the trial is not a
after
license.
Tarsamlal, there is no apprehension of arrest. Because when, once we are not arrested during investigation, so there is no apprehension of arrest. Here, my lord, they say FIR, your lordship knows, once FIR is registered, ED investigated, file 45 application, complaint has been filed. And after receiving summons, they are not appearing, going on taking time.
Good.
That is the only question, your
And
lordship.
almost in all the matters, this is decided. Yes.
Your lordship is fixing it, my lord.
Okay, yes. Read.
Well, there was an interim arrangement that may be
Yes,
continued.
sir. Whatever, it is. Yes.
I'm great.
See.
Yes, sir.
Matter. Released on conditions. I've complied the conditions. Vehicle not released.
Yes, yes. That appeal is pending
Yes.
against confiscation.
My
order.
lord.
Yes,
Already vehicle has been confiscated.
that I know.
My-
What he says
After
is
confiscation-
confiscation order is subject matter in an appeal.
My-
Appeal is a continuation of original proceeding.
In our-
Therefore, can the order passed by the 457 court can be complied?
Your matter, whether hard question is or whether in a confiscation proceeding, while pending with before the authority officer, whether the magistrate has the jurisdiction that has to be minor that is in CRLMC number 2639 of 23 that has not been clarified. In our High Court judgment. Because of long pendency, nobody will benefit for that reason honorable this honorable court has.
No, it is only interim.
My lord, my lord. 56, my lord, there is a specific bar on interim day. 56 of the forest.
No, that is already settled.
My lord.
Interim release can be done during the pendency of the confiscation.
My lord. Thereafter, my lord, after being confiscation, my lord, the petitioner approached this honorable court in a CRLMP. Your lordship kindly have glanced the order.
Where is that order?
Annexure 1, my lord, very.
Annexure 1.
Yes. Rule court. The London Council constituted referring to the affidavit of the head officer Jawaharlal and Jawaharlal submit that in the meantime this vehicle is in terms of the order.
The council was referring to the affidavit of
Convicted conservative of police conduct in vehicle is confiscated. In view of which there is no further scope of this court to exercise. Now, my lord,
My lord, after this proceeding, I have filed the appeal before the district judge. Now appeal is pending.
During pendency of the appeal, my lord, he may file a interim petition there. I am, my lord, against that order, he may come in the writ petition. Now, my lord.
No, when the confiscation order was passed? Date?
Confiscation 24/1.
Huh?
24/1/2024.
24/1?
2024.
See, the High Court order in Annexure 1 is 15/3/2024.
24.
Then?
When I filed CRLMP, prior to disposal of the confiscation proceeding, in the meanwhile, when confiscation.
No. You say confiscation proceeding is confiscation order was passed on in January 24.
January 24.
And this is March 24. This court has said that will not interfere. Then
Your Lordship.
I can't overreach this order now.
I have shared this fact before the honorable court that my case is covered by Taranji Mehra case. That if appeal filed, before
I can take the victim order.
Yes.
Hon'Ble can dispose of in CRLMC case. Government filed CRLMC, I filed CRLMC, then both the case disposed of. Then you have filed your CRLMC.
Where is those things? These things are not written in the order.
Not see.
Where is that? Just see, Learned Counsel for the state referring to the affidavit of range officer, so and so, so and so. In the meantime, the seized vehicle, in terms of the order passed by the authorized officer come assistant conservation of forest, the vehicle in question has been confiscated. In view of the same, there is no further scope of this court to exercise the jurisdiction. So and so.
And the appeal fact is not here.
How will I read it? All these things, whatever you are saying in this order.
After the confiscation proceeding, I have filed.
You file a response.
I have filed appeal in my.
I understand, but I was with you for this order of justice nursing. Now it's a problem.
There are a number of cases before this court. First of all, a principle decided by the division bench.
I know that is why I was with you.
A lordship.
Even now I am with you, but how to get out of this order?
Saying I have not followed. My case that I have challenged the confiscation order.
You need not repeat these things, sir. I know by tips, I know the facts.
What is telling I am not followed? What is submission? That is telling that appeal is not maintainable. I will not take the vehicle. What is saying I am not followed?
No, what he is saying is not important. What I understood is more important.
Yes.
Because I have to write the order.
Yes.
He will not have it. See, there is an order, there is an observation made by Justice Nursing, which dilutes your, case. So therefore, how to get over this? I can't sabotage this order by passing another order.
Fine.
You made the same prayer by filing a CRLMP and you obtained this order. That's the problem with you.
Order, order passed.
You file a reply to this. File a reply to this.
Lordship. Again,
What I can do is, what I can do is,
lordship passed order in Talent Mehra case, and also your lordship's judgment is there. Now same thing, again and again, 3 times have come, and now he claimed the same
I
thing.
understand, but he is pointing out an order.
The case is, I can take the vehicle at least till disposal of appeal. This is the order passed by the consistent by your lordship also. Consistent order is that apart. Confiscation portion disposal not affect my case because I have taken order in criminal proceeding to BCC case. Then if the confiscation proceeding will be disposed.
Why have you filed a CRLMP? Why have you filed a CRLMP? Why have you filed a CRLMP?
CRLMP
To obtain this observation.
Yeah, CRLMP because they have not complied the order. I filed CRLMP. Direction was given to range officer to release my vehicle. I have complied the condition.
The court says since confiscation order is passed, I can't do it. Now how can I overlook that order? You tell me.
The start of the matter. 3 months they didn't release the vehicle. In spite I filed CRLMP.
You please answer, please, sir.
Dispose of the confiscation.
Sir, please answer my question. If I am wrong, you just tell me. Your case is there is an order pass in your favor for release of vehicle. 1 minute. 1 minute.
Order is passed. One order is passed by this honorable, therefore your lordship adjourned.
Adjourn it. You are not able to appreciate. Please have patience of hearing me also. If I am wrong, you correct me. Your case is a release order has been passed in your favor.
Yes.
Okay. That is not complied. That is your grievance. Why it is not complied? Because by the time the release order was passed under 457, confiscation order has already been passed.
No.
1 minute.
After 3 months.
After 3 months of confiscation order is there. Then the court says that since confiscation order is there, I will not release it despite the order. 1 minute. Then you file an appeal against the confiscation order. Appeal is pending. What you are trying to say is, since the appeal is a continuation of original proceeding, so the confiscation order has not attained finality. So therefore, the interim release order which has been passed has to be complied with. That is your case.
Yes.
Since it was not complied, you file a CRLMP. CRLMP court says, now confiscation order is passed, so therefore I can't pass the order. How can I dilute that order? You tell me.
I said, Here only they say-
3-line order, I can understand English.
Disposed of. In here only.
So therefore, I can't pass the order for release. That's what the order is.
Disposed of.
How will I overcome that order? You tell me. Otherwise, I am with you.
And the question of filing of appeal was not there at all. Before the CRLMC of.
Where from the order, where will I get?
After I.
When you file the appeal? When you file the appeal? Tell me the date. Tell me the date when you file the appeal.
CRLMC.
Appeal.
Appeal I have filed. I have written here.
Give me the date.
2/3/2024. FAO number.
Okay. 2/3/2024. And the order of Justice Nursing is 15/3/2024. After your appeal is filed.
The last court have not observed that I have filed appeal.
May not be observed, sir. You try
I am
to
not
appreciate
able
what
to
can
get
I
the
what can I
objection.
do?
They said that
You have
then the matter disposed of.
I don't know. You have invited this observation. How will I get over this observation? Otherwise, I am with you. I am completely with you. It should have been released till the appeal is disposed of, because it is the interim relief. It should have been done. But you have invited this.
I haven't.
Okay, let us not further waste the time. You file reply. We'll see what can be done. I'll try to find out some way. Let me see. Wait. Let me apply my mind.
1.5 years already passed. Several times, 8 times I have.
Reserve the judges, give it. I'll pass here. Yes. Do you have any judgment to support your case? Do you have any judgment? When
Yes,
appeal is pending, interim
Yes, yes.
release can be affected, you give that judgment. Okay? I'll pass. But they do. Let us not be for the time. Yes. Yes, I'll pass the order. Which paragraph, by the way? Let me. Which paragraph, sir? Which paragraph?
That operating portion subject to.
Which paragraph of this judgment? You underline it and give it up. Yes, 5. Item 5. Underline it and give it. Yes. Yes.
May I please, Your Lordship? Item 5.
Yes.
Item 5, the matter has already been compromised between the parties. One date may be fixed so that both parties.
Appearance.
What are the offenses?
417, 493, 506.
Date may be fixed so that both the parties will appear before Your Lordship.
Next week.
Fix it.
Item 6.
Yes. Possible.
Item 8.
Possible. Yes.
Item 9.
Possible.
Item 10.
Please, Your Lordship. Lordship, in the previous occasion, it was directed to file their response. Opposite parties.
I am for the informant. I'll serve a copy of my affidavit.
What do you want?
Lordship, let them solve the file their response.
Huh? Sorry.
Lordship, in the previous occasion, it was ordered that opposite party seeks adjournment to file their response.
I'll file affidavit. I'll serve the copy of the affidavit. And for the informant.
You want to file?
Yes.
Okay. Counsel for the informant seeks an adjournment to file the response to the petition. Let him do so within a week. Please the matter. Yes. Okay.
Item 12.
Next. Yes.
May it please Your Lordship.
Yes.
The petitioner's husband has been murdered. Trial went on. The public prosecutor closed his case.
But certainly the learned court has given further time. In the meantime, your lordship may kindly look at page 9, order dated 27/9/23. Page 9 of the brief.
Yes. Yes.
The relevant direction of this honorable court is at page 23, para 16. Page 23, para 16.
Yes. In view of the above discussion, football decision of not agreed to transfer.
This honorable court had granted 3 months' time, as early as on 27/9/23.
Yes.
You submitted that case where the officer has
Now,
dragging the word used.
Yes.
He has submitted that on 20th January 25. He has submitted the charge sheet.
now they have filed a charge sheet again with ifs and buts.
That's a different story.
No, there must be, my predicament is that unless trial is concluded, the accused persons may be granted bail, and once they are granted bail, nobody knows whether they will be.
Your grievance was only that despite this court order to file the charge sheet within 3 months, it has not been filed. Somehow it is filed.
No,
though it is delayed, but the fact remains that it is filed.
Yes, it is filed.
Then you have
trial must be concluded within a particular period. Trial
I don't
cannot-
know how many witnesses are there. Nothing is there.
That is what they must say.
How many witnesses?
No, not many. The state should say. The state should say.
You are appealing for the accused.
No. I am not accused. What happened, my lord? The investigation was completed.
Who are you, by the way?
I am the son of the deceased. I invoke the power of this Honorable Court on Section 482 that it requires further investigation.
By CBA?
No, further investigation by crime branch.
138 and all.
On my prayer, this Honorable Court passed an order directing the crime branch to took up further investigation on the points pointed out in the order itself. On basis, investigation was carried on. Thereafter, subsequently, the IO submitted final charge sheet. And the trial is going on. Trial was not stalled. In the meantime, my friend's grievance is that the investigation is going on. Direction will be given to closure the investigation. That part is over. That is no more. Now, expeditious trial of the case. Unless and until you know what is the number of quantum of.
That's what I'm asking.
So, if
can you tell me how many witnesses are there?
Has been examined and
all the witnesses in the first charge sheet, they have already been examined. Thereafter, the PP submitted a closure of his.
Try to appreciate. See, this kind of order without understanding anything passing
That is for the
is
state.
pressurizing the trial court unnecessary. Unless you give me a calculation, these are the witnesses to be examined and all, then a practical time frame I can.
Why I submit this ifs and buts is, they say that it has been sent to Netherlands for 3 years, that for 2 years they did not do anything. Now they say the matter has been referred to Netherlands.
Okay, then I'll pass and
No, the state must say what time they will take.
I will take one.
The state must say what time they will take.
No, I'll simply say that the petitioner being the accused has a constitutional right for speedy trial. So therefore, it is expected that the trial should be concluded expeditiously.
Unless it is done again the same thing. Again, I will have to come. Either he may have to come or I have to come. We want proper.
If I
trial.
pass, suppose I'll say 6 months, then the letter keeps on coming from the
Again, my lord,
extend the time, extend the time.
Your lordship has seen on 27/9/23 this order was passed, and now almost 2 years.
You give a rough calculation.
Yes, that is what I submit.
Next week, madam.
I'll put it. Let him give a rough calculation.
I am requesting this Honorable Court to overcome all the anomalies. A report be called for from the trial court. How many witnesses are examined till late and how are remaining. So we can appreciate whether a time frame can fixed or not. That will be better.
All the witnesses had been examined.
Right.
So now, take it. Therefore, it is for the prosecutor to say how many examinations they are likely to examine. and what are the materials they are likely to put
Precise
up.
grievance of the petitioner in the present case is that despite the order of this court dated 27/9/2023, passed in CRLMP 1472 of 2023 to complete the investigation and file the report within 3 months. The IO has not yet filed the charge sheet. The notice was issued to the state, and eventually the IO has submitted a report inter alia stating the charge sheet is filed on.
Yes.
Charge sheet has already
28/1
filed.
25.
25?
21. 21/1/25.
21/20.
28/1/25.
At this stage, Mr. Pujari, learned counsel for the petitioner, seeks intervention of this court, directed to the trial court for expedient disposal of the trial. Being head to the contention raised by Mr. Pujari, which has been strenuously opposed by Mr. S.C. Mahapatra, senior counsel. I feel it appropriate to call for a report from the trial court regarding the status of the trial.
Next week.
Please the matter after receiving the report. Yes.
13. It will come from lower court, madam. I will also submit.
You also submit.
May I please your question?
That's
on the first order.
Tell you to release the matter after receiving the report. Don't delay. Yes.
13.
May I please, Lordship, on the first order, Lordship direct to file the protest petition and 202 statement, Lordship. I already filed the protest petition and 202 statement, but it's not showing in the noting. So, Lordship, kindly list this matter on next week, Lordship.
No, it is there already. Protest petition is there.
Protest petition is there.
Is there?
Lordship, I have not prepared for not showing in the notice.
You have not read it.
Yes, Lordship.
I'll just adjourn it, read it and come. Okay.
Lordship, next
Okay.
week, Lordship.
Simply adjourn. It is there, already there.
Oh, bless
Okay.
Lord.
14.
Yes, sir.
I may permit to withdraw with the liberty to move the learned magistrate.
What are you challenging here?
Permit to withdraw.
You are challenging your cognizance.
Against the order issuing NBW because he was absconded. The police absconded. Justice Summit.
I'll quash it, go and appear. I'll give you date. I'll quash the NBW and give
yes,
you a date, go and appear.
Yes.
Why are you unnecessarily asking for that? Huh? Right on. Petitioner is agreed by the order dated 20th November 2023, passed by learned JMFC Chilka in GR case number 393 of 2023, whereby non-bailable warrant has been issued against.
Not in the case of Belgium. He was absconded. Charge sheet was submitted.
Because full sir, because it is stated that the petitioner has been absconding. Mr. Das and counsel for the petitioner submits that on instruction submits that his client would be appearing surrendering before the court on or before 20th of April and resort to the remedy available to him under law. Regarding head to the statement made by the counsel for the petitioner, the execution of NBW order issued on 20/11/2023 by the JMFC Chilka shall remain stayed till 20th of April, subject to the petitioner appearing or surrendering before the court below and resort to the remedy available. You go and appear, whatever has to be done, it will be done. Yes.
15.
15 will not my humble submit.
It's kind of anticipatory bail till 20th. Interim anticipatory, kind of.
Milord, here is the case, Milord.
15.
15 Milord.
Yes.
I'm for the wife, Milord. I filed domestic under the Domestic Violence Act, Benevolent Act. I pursued the matter for since Milord the filing 2017. But one day after in the COVID hour during COVID epidemic, Milord, I didn't take any step and the matter was dropped as dismissed.
for non-prosecution. My humble submission, the court having the power to dismiss for default includes the power of restoration. Therefore, your lordship will make an application for restoration that shall be considered. Because the court
So
has
your application under section 12,
section 12 of the Domestic Violence Act.
but dismissal for default.
Yes, but page 35, may invite your kind attention. The learned court drop the proceeding.
I'll issue notice then.
17 your restoration.
What do you say? Dismissal defaults. He has the right to restore it.
How the matter decided, because in creating point, whether the power is lies.
Forget it. Don't, lot of work, no technical academic.
I got technical. That from the
academic power is there now, but I can restore it in 482. I can restore it and let the law will take its own course. It was dismissed at what stage? Dismissed what stage?
Yes.
At notice stage, you tell me what stage?
What stage notice was sent.
Notice was already served on that.
Already sent to the opposite party. They have appeared, except the husband, all other opposite party entered.
That stage it was
At
dismissed.
this stage.
Then I'll issue notice, let them come. Let them come. It may be settled also.
But it will settle, yes.
I'll simply issue notice.
It can, yeah.
Issue notice. File the requisites, let us see. Yes.
70.
May I plead the lordship? My lord, the petitioner is working as a peon, and the petitioner and the informant's family have civil disputes. They belong to members of the larger family. They had been to, my lord, land acquisition office to receive their respective payments. There the informant alleged that I abused her in filthy language and lost an affair. Only with an intent that I am a government servant working in another district as a peon. If I will be embroiled in the criminal case, my service career will be in jeopardy.
I'll issue notice.
294, 330.
Informant not added as the opposite. Informant not added as the opposite part number 2, your lordship, in this
See,
case.
that's the whole difficulty. Why don't you do it? These are the matter which can be settled. It is the ego issue.
But with great response, I'll serve this extra copy.
But
No, you implead her. Impleading. Let counsel for the petitioner take leave of this court to implead the informant in the present case is opposite party number 2. He may do so within by tomorrow. Issue notice to opposite party, newly impleaded opposite party. Mr. Mahanti accepts notice for to take. Take out the notice first.
Along with the IA, I will file also a consolidated cost.
Yes, consolidated profit. Do it immediately. I'll give you after 1 week or so. Give it.
And stay up for the proceeding.
I don't know.
It has been submitted. Annexure 2.
17 item. Yes. What is the says?
Charge sheet has been submitted. Is in magistrate travel of him. The case is pending before the London magistrate. SDGM Balangi.
I don't know what is the says.
Trial is not commenced.
Then what is say then? I will decide it in 1 week. What are you talking? Bring them. I'll decide it. Yes. If I'll give stay, then you will be vanishing somewhere.
In cases where I have stayed, I have prayed before a lordship.
Okay, it's all right. You bring him, we'll settle it here. Okay. File the process immediately.
Tomorrow I will file the process as well as the IA and consolidated cost.
Yes.
Great.
Item 18.
In the crossing of the entire criminal proceeding, 307. Case, counter case.
Pass over.
Yes, your lordship.
90.
May I please, your lordship? Pray for passing of FIR. May I pray one thing, my lord, director to surrender, my lord, first of.
Sorry?
Director to surrender, my lord, first of, second of, my lord. For parity, my lord.
Your bail application rejected?
Okay, well, my lord, rejected, my lord.
Where have you said, where is the order?
No.
No, you mentioned earlier approach.
I only pray, my lord.
Where have you said that? Where is the order? You applied for anticipatory bail, which is rejected. You will keep it secret.
No, my lord.
Where is the order then? What are the observations? I don't know. How can I pass an order? I may pass some order which may overreach that court's order.
That is only rejected.
Give me that order.
My lord.
Pass it over. Pass it over. Give me the order, otherwise I'll dismiss it.
After launch.
On the ground of concealment.
After launch,
Come with that order.
my lord.
Otherwise, I'll
After launch, okay.
20.
Yes. No. Pass over. Yes.
21.
My lord, item 21 and 27 on behalf of Mr. Tripathi, pray for 2 weeks after.
On behalf of Mr. Bimokis Tripathi, an adjournment is sought.
21 and 27. 21 and 27.
27. Please the matter after 6 weeks. Yes.
Obliged.
22.
Beg your pardon, sir. I'm in busy. Sir, in this item, I am appearing for the petitioner. Sir,
Yes.
what happened is the petitioner has been debarred from getting a passport due to a previous pending case in JMFC Bhuban. So my humble and simple prayer is that kindly quash the FIR and give.
The prayer of the petitioner is very innocuous, kindly.
No, how can that be a ground, sir? Because of the pendency of criminal case, you are not being issued passport. Therefore, quash the criminal case.
Sir, it has been since from 2020. The FIR has been.
Whatever you on merit you satisfy that no case is made out against you. But merely because passport is not given to you, therefore quash the FIR. What is it? That may be a consequence of the pendency. That can't be a ground.
But the case is not getting proceed further, sir. It has been pending since 2020. And
you just satisfy me what are the merits of the case?
Offense was 269. Summary without using max tax second level, that is 269. That was pending. Therefore, the petitioner was not able to get the passport.
That's a different story.
Yes, that is different, lordship, that can be approachable by final writ application. But quash on the grounds of to get the passport is not permissible.
Where is the ground? Let us see.
Grounds.
Only one case. Your remedy is very easy. Your remedy is something else. You have to file a writ petition. I'll record that and dispose it up. Okay. I'll record that and dispose it up. Okay?
Yes, yes,
Petitioner is seeking quashing of the petitioner is one of the accused in Bhuban PS case number 92 of 2020 for alleged offences under section 188 and 34 IPC.
Sorry for the interference. You have to approach that court for permission. If that court permits.
That's what I'm giving that liberty.
Otherwise, we directly cannot file here without approaching.
That's what I'm saying. I'm giving that liberty. Young man, he is. Yes. And read with section 3 and 51B of Epidemic of Disease Act 1997 and Disaster Management Act 2005 respectively. The sole ground on the basis of which the petitioner is seeking quashing of the FIR is that the due to pendency of the pendency of the criminal case, the petitioner has not has been denied the passport. He in the petition has contended as under. Para 4, page 4, on the ground of non-issuance of the passport to the petitioner, the FIR cannot be quashed by invoking jurisdiction under 482 CRPC. The remedy for the petitioner lies elsewhere. Therefore, although I am not inclined to entertain this petition, however, liberty is granted to the petitioner to resort to the remedies available to him under law before appropriate forum. With this observation, petitioner is disposed. Yes.
23.
My lord, on behalf of Mr. Guru, kindly taken up item 23 next week.
Depending on behalf of the opposite party, my lord. I have filed my local related to the industry.
40?
23, my lord.
23.
I am for the
Yes, sir. You are appearing for?
opposite party, my lord. He's been convicted by the Islamic court.
The next week.
And there is a request on behalf of the petitioner for an adjournment.
Next week, my lord.
On behalf of Mr. Guru, there is a request for adjournment. Leave the matter also, Mr. Guru. Yes, Mr. Ashwini Kumar Das from police court. Okay.
24.
3 weeks.
Next.
May I please, my lord? Petitioners are ladies. Challenge the order of cognizance by Annexure 3 of alleged offence under the 307 and others allied offences. The informant is the police officer. Kindly see the FIR Annexure 1, where the police officer informant says that where they admit to the house of another, the entire village people, my lord, including the ladies, all, my lord, assaulted to them. That is the allegation. Thereafter, police investigator filed the charge sheet. Charge sheet, my lord, thereafter cognizance taken 70 persons, including the petitioner who are ladies, my lord. And my lord, the injury, there is no such injury, my lord, I think so. And police says, including the ladies, all are assaulted. Total, entire village, there is nobody left filing of charge.
The police might have gone to the village to arrest someone, and you might have attacked.
That's even assuming for a moment that they have assaulted by the men people, but the women are not responsible.
Let us come to the statements and all. Who has taken your name?
They have to.
Page 51 also, kindly.
Petitioners, ladies are having small children. That is an unbelievable story, my lord. Petitioner lady, they have not assaulted, my lord. Even their husband might have, my lord.
You might not have, but see the evidence, whether any evidence has come against you or not. One after another, let us see. If nobody has taken your name, you are out.
Intentionally, they have added my petitioner's name.
I don't know. I have to ask them whether intentionally.
Kindly have a glass to a fair story.
You don't give those story. You tell me what are the evidence against you. Or if there is a, see, it is only cognizance taken.
Cognizance taken. Then that cognizance, thereafter charge criminal, the petitioner will face their trial, my lord, having a small.
That is a different consequence. You tell me what are the evidence.
And allegations, my lord, regarding assault, nahi, my lord.
Show me then. Show me that.
Injury
there is
report,
no allegation of assault.
My lord, they may state may produce the injury report. How many police officers are injured by assault of the accused
Charge
person.
sheet is filed. Copy supplied under 207.
I have also filed, my lord.
And why have you not filed? Why have you selectively filed things?
No, entire charge sheet copy I filed.
Then the injury report must be there along with that.
Okay, other the injury report, but certified copy with me, my lord. Also, kindly see there is no injury report. Therefore, I am saying, my lord.
You should have asked them there in the trial court. You have not supplied the entire copy.
No, police they
That right you have under 207.
Police is the informant, my lord. Actual, my real, my lord, field reckon say they got to 9, my lord. It is not an unbelievable story.
50.
51.
Mid person of lordship. May I read your lordship? While they were conducting raid in the house of Jagabandhu Das, situated in front of house of Shamsundar Barik, suddenly accused persons, namely Sabita Barik, who is also one of
all the
the
names.
Milli Barik, Bharati Barik, Sumitra Das.
It is, yes, leave the names.
Taken the name.
I am assault to
the police officer. Yes, I already injured in this case.
How much? You said might have been injured by the male person, but how the
Lathi, Bhujali, sword, iron rod, bricks, stones, baits, all of a sudden become violent and attacked our police team.
And absence in
male person स्त्री लोग कौन एगुड़ा धर की माइलर assault करते पुलिस को. That is unbelievable story, my lord. Your lordship therefore saying, my lord,
You please assist the court. Don't give the general stories and this thing. Assist the court on the basis of material.
What my
The story will not help you.
What my friends read out, my lord. Further allegation regarding the petition assaulted to the
Your name is there.
Allegation
They have said that all these people were holding bujali and sword, iron rod, bricks and all. How will I distinguish it? And if the cognizant says, I'll see everything, appreciate and discharge you or.
No, I'm just not saying, my lord. I'm just humbly submission, my lord. That injury report is saying dekhantu the amara dwara se assault heichhanti. How many police person injured by the assault?
Gadi damage kole namko gadi
Long and short of the story is, you have filed a petition without annexures and you are asking the state to give the annexure. That's the long and short.
My lord, entire certificate copy with me injury report was 9 million. My bona fide lordship kind of a glass petition or lady.
What kind of petition you have?
My friend may directed lordship to file the
161 statement you have.
Senior not filed one statement, but for the time being, I know the one statement of the witness examined.
certificate copy lordship kind of a glass. मैं entire file करची मिलट.
Certificate copy जहाँ मांगिले ताको देवे ना. Charge sheet बोली मांगिले charge sheet मिलियो. Charge sheet अलग होगी document मिलियो. आपण charge sheet मांगे क्या certificate copy भी मिलियो. And you know better than anyone else. Certificate copy जहाँ मांगी भी ताको मिलियो ना. Can I record your statement that nothing is supplied to you?
ना मत्ते
why are you? See, don't tell all this story to me at least.
ना मोर जहाँ अच्छे मुझे आप फाइल करची.
If you ask for first page,
I humbly pray, my lord.
Is it your case that under 207 accept the charged copy, no other document?
I'll not say so, my lord. But my humbly submission, my lord, the lordship having taken my consideration of the petition as well, my lord, the lordship may direct to provide the injury report, whether that
you file it. Or otherwise make a statement that nothing is. I'll got hold of that.
I will protect.
You file it. Let us consider the petitioner seeks an adjournment to place on record additional document to substantiate his case. Let him do so within a week, least after.
My lord, I file a miscase, my lord, miscase.
Incomplete petition and thereafter miscase. What are you?
What a ladies are kindly same.
Next item.
Khali gotte date pai hame khali.
25.
You should have come with clean hands. You are making out a case 307. Attack to the police team, not a single person. And they have gone for a duty. You entire village attacked. And with all weapons. And you make out a case for quashing. Cognizant stage without filing document asking for stay. Is it not absurd? Have you heard anywhere in the world this kind of thing?
Short date kari gote dele
short date that I can give.
In the meantime, my lord.
That's the problem. You should have filed a full petition with all documents and yes. Give a short date. Let you file the all documents. We'll see. After a week.
25.
Yes.
25 307 for quashment. I think no file the charge sheet, injury report, nothing has been filed. Only due to settlement. In the governments in the miscase, they stated that the amicable settlement has been made.
What are the injuries?
Injury report is not filed, but has not filed.
See the FIR?
Yes, sir. Page 10 your lordship. Maranastra ko may read your lordship.
किंतु गणेश नायक
तो मोर सान भाई जहाँ मना करथिला किंतु गणेश नायक ता कथा न सुनी नथिला रागरे घरु मारणास्त्र आनी ता मुंड को ता हाथ को नृशंस भाबे आक्रमण करथिला तापर गणेश नायक से जगह छड़ी पळाई येथिले प्रदीप कुमार नायक आहत अवस्था रे पड़िथिले तापर तांग घर लोक तांको मेंढासाल हॉस्पिटल को नैथिले मेंढासाल हॉस्पिटल फेराई देबो
डेडली वेपन हेड इंजरी
that stated yes your head injury so
let him come, we'll see.
Possible?
Yes, possible.
Yes, sir.
26.
This case, my lords, the petitioner
item number 25.
25?
Yes, sir.
1 minute. Yes, 25.
My lord, item number 25. This is maybe network issue. I may not join in the time. My lord,
Yes.
kindly issue the notice to the opposite party.
Why should I issue notice?
Petitioner for compromise. Sir, matter ta compromise ହେଇଯାଇଛି ତାଙ୍କ ଭିତରେ settle
It's a case of 307.
Yes, sir.
You have used
Yes, my
deadly
lord.
weapon and head injury.
Yes, my lord.
Compromise means it will be done like this. You have to substantiate the case. What is the stage of investigation? Except FIR, you have not filed anything. What is the stage of investigation?
Injury report has been submitted to the police officer, but they are not.
24 FIR. I have no instruction for the time being, but I think charge sheet not been filed. It was in November FIR ହେଇଥିଲା 2024 ରେ.
Whether he was there in the hospital.
Yes, that part I have no instruction.
Nothing is written,
Yes,
nothing
yes,
is there.
yes, that is there.
Just one page petition, was it? What kind of petition you have filed? Only one page petition, annexer FIR and quasi.
Sir, we don't have the CD from the police and charge sheet.
Petitioner is seeking quashing of the Chandaka PS case number 385 of 2024 registered against the petitioner in the instance of opposite party for alleged commission of offences under section 109 and 118 bracket 1 of BNS, which is presently pending before AMFC bracket O Bhubaneswar. Except the copy of FIR, nothing is filed along with the petition. The petition, even the petition is vague. There is no specific averments made regarding the nature of injury or etc. The petition being a vague petition, the same is dismissed with a liberty to the petitioner to file a better petition with better particulars and relevant documents. Yes, you file better affidavit, better petition. Okay. Okay. Next.
Oblige, my lord. Oblige, my lord.
May I please? During the trial, my lord, inadvertently the present petitioner not asked some questions to the PW1, my lord, for which he has filed a petition under section 311 of the CRPC to recall the PW1.
Where is that order?
Annexer 1 is the order passed by the trial court rejecting my application. My
Let us see what are the
against the confirming order. 11.
That is page.
First appellate court judgment page 18.
Page 18 is the revisional court.
First appellate court.
Trial court's order, my annexer 1, that is the relevant part of the.
Who is PW1?
PW1 is the informant victim, my lord.
What are the offences? You have not filed the
offences under section 354A and 294, 323.
Where from I will get it?
My lord.
You have not filed the charge sheet, nothing is filed.
Only.
Where is the evidence of for the PW1? Whether you have cross-examined him or not, how will you know?
I have cross-examined, but inadvertently some questions are not put.
What are those questions? Where is the application?
Application means annexer 2. Even the schedule of the question.
311 application.
And at page 15 minutes, you can have a glance at page 15, annexer 2.
15.
Schedule of question to be asked to the print format. I framed the 6 questions.
Do you have the statement of the evidence of PW1 with you?
I have not.
Give me at least. Give me that. At least I will just compare whether these questions were already put to the witness or not. 5, 6 questions.
I obtained my letter.
Give it. Shall I pass it over?
No, my I am not obtained this.
See, unless you file the statement of the evidence of the PW1.
So day after tomorrow.
How will I come to know whether these
On
questions were already put to him or not?
Lordship put up on Monday, I.
Not Monday, it will go after Sunday.
Well,
You are spoiling your case unnecessarily. How will I come to know whether these questions are relevant or not? See the questions,
That is-
one paragraph questions. Just see the question number 1.
that is 6 questionnaires.
One page, one question. Second question is little smaller.
Well,
What is this question? What is the relevancy of these things?
because some contradiction.
Just read the first question. One page.
Yes,
What is this question? What do you want to ask?
whether you have stated before the IO during the course of examination under section 161 CRPC that on 19/4/2021 at about 9:30 p.m. your villagers Alauddin Khan, Akbar Khan, and Kaliuddin Khan, and some other minors
Made an unlawful assembly being armed with weapons.
being armed with the, such as rod, pipe, sword, crowbar, etc. And standing in front of our house and abuse us in most Hindi and obscene language and challenge.
You give the statement first. Learned counsel for the petitioner seeks an adjournment to place on record the testimony of PW1 who is being sought to be recalled by moving an application under section 311 CRPC, which has been rejected by the court below. Let him do so within a week, at least 3 weeks. Yes.
By Monday.
Monday not possible. Yes.
28.
If you have the copy, I can read it and pass the order.
I'm not it's available on trial courts.
Yes.
I can get
This
it.
was the minimum document that should have been filed. Yes.
Monday I can obtain it.
Monday is not possible. We'll see. Okay, right. Yes. Up to
28.
Ma'am, please, your lordships. Petitioner has challenged the order dated 9th September 2023 in city case number 176 of 2021,
Yes.
passed by Learner SDJM Devagad in local adalat case, my lords. My lord, in subsection 3 of the section 20 of the Legal Service Act makes it clear that local adalat can dispose the matter by way of the compromise or settlement between the party. My lord, the petition was
The affair became FRT, though the opportunity is given to the informant to file the protest petition, not filed in time. Accordingly, the matter was referred to in the local adalat, and local adalat, the matter has been dismissed. That counted challenge before this in this application also. That is page 14, impugned.
14, huh?
Yes.
My lord,
14, huh?
Page 14, 1.
Yes.
The 14 election data from those. No, you said 14.
The case is put up today with national.
The case record is put up today on National Adalat for order. And for example, the case record is found that the information on this case doesn't appear even after the summon was served on him personally and the SR is returned with sufficient service. This case is lingering for filing protest petition by the informant or informant. Also, notice under section 173 CRPC has been successfully heard intimating about the final report of this case as FR files. Still then, the informant didn't turn up to file protest petition. In addition to this case, in spite of notice of this court has already been sufficiently served, so there is no need to linger this case for further.
How can the local adalat pass this order?
Your Lordship, we need to minimize the pending cases.
Well, that's all right, but
yes, I'm not.
That's all right, but
yes,
see,
that is.
local adalat can't pass this kind of order.
But there is so many cases are pending like this before the.
That's right, but what to do if
refer to them?
But now he is making a grievance. And that grievance is genuine.
Yes. That's it.
When the closure report was filed?
Unless 2 page 10, my lord.
Yes.
Page 14, my lords.
Page
14.
14. That is, I understand. That is the order of the local adalat. When the charge sheet was filed, closing report was filed.
Yes,
the hopeless practice of this court, I have seen that the documents are not filed.
That is, Lordship finds in page 12.
And the court, the local adalat say that you have opportunity was given to you file protest petition, but you have not filed.
By charge sheet, my lord, charge sheet files on 28th.
Where from I'll get it?
Page
June.
12, your lordship, kind
12, 12, my lord. Page 12.
Order
Order
number
6.
Is
12, my lords.
page
28/2022 ରେ ଫାଇଲ ହେଇଛି।
Where is that?
Serial number 6,
Record
order number
put up
6.
today.
PF
not received. File form not received.
Issue summons to the informant of protest petition if any date fixed by.
When the file form was filed?
Page 12, your lordship, this order number 6, your lordship.
Order number?
6, your lordship.
Yes.
Second paragraph.
Filing form number so and so.
Yes, my lord.
So and so. Is sufficiently received from so. What are the offences?
My lords, 120B, 420 and 34 IPC.
So 2022.
22 ର ଏଟା ହେଲା order pass ହେଲା 23 ରେ. Near about to 1 year, 3 months, your lordship.
Are you seriously you want
Yes.
to file protest petition?
Yes, my lord.
Serious? How much time will you take?
2 weeks, my lords.
2 weeks ନିଅନ୍ତୁ ବରଂ କରନ୍ତୁ. So that
Yeah.
rights ଟା curtailed ହେଇଯିବ. I am not disputing.
Petition is agreed by the order dated 9/9/2023 passed by Lok Adalat held on 9/9/2023. 2023. The AGM Devgod by Lupin order has closed the opportunity of this protest petition on the ground that though the charge sheet was filed on when charge sheet was filed on, where is that date?
28th June.
Charge sheet was filed on
28th June 2022.
28/6/2022, and the notice under section 173 was served on the informant. However, the informant did not file the protest petition even after affording several opportunities. Therefore, the STJ Devgod, while holding the Lok Adalat, has closed the case. Close the case. Petitioner is agreed by the same and has filed the present petition. The counsel for the petitioner contended that the Lok Adalat has no jurisdiction to pass the issue on. Mr. Mohanty, except Mohanty appeals for the state, submits that indeed the Lok Adalat has transgressed its jurisdiction by passing the impure order. Therefore, the petition impure order regarding it to the impure order is satisfied. The petitioner is granted 3 weeks time. 3 weeks time to file protest petition if protest petition if any with this petition is put up. 3 weeks time I am granted.
Restore the 17 city case number 171 of 2021.
ସେଟା ଫାଇଲ ହେଲେ ବୋଧେ automatically restore.
Which one?
ସେ ଯୋଉ FIR ରେ ଯୋଉଟା
Close
ହେଇଥିଲା
ହେଇଯାଇଛି
ସେଟା
ତ।
ଯେହେତୁ dismiss ହେଇଗଲା ଏଟା ମାନେ opportunity ଦେଇକି ତେଣୁ ସେଟାକୁ record consign to record ହେବ ହେଇतो.
Okay. Restore the where is that item number କେଥିଲା? 28. Huh? 28.
Restore
City case number 176 of 2021.
176 na?
176 of 2021.
176. Restore
City case.
the CC case number 176 of 2022.
21 year old.
21. What is that number? Yes. CT case number 176 of 2021. 245. Yes. Yes.
29.
Item number 29, we have Mr. Bhavani Sankar Mishra, kindly to accept.
Sorry,
We have Mr. Bhavani Sankar Mishra, kindly to accept.
on behalf of Bhavani.
Bhavani Sankar Mishra.
Prayer made on behalf of letter counsel for the petitioner Bhavani Sankar Mishra for judgment means the matter for 6 weeks. Yes.
30.
May I please list? My lord, praying for withdrawal, my lord. Praying for withdrawal, my lord.
Sorry, madam.
38. No, withdraw, my lord.
Withdraw.
Withdraw.
Withdraw. Huh?
31.
May I please, my lord? My lord, here in this case, the sole petitioner is facing his trial for the offense on section 363, 366, 376, 1 IPC, related to section 6 of the POCSO Act, along with the SC/ST Act. My lord, in the means, by the time of occurrence, the victim was more than 17 years. However, in the meantime, after she tendered her evidence before the court during trial, she and her mother, who is the informant, the matter has been settled between them parties, and they got married, have been blessed with. I moved an application before the Lawrence Court below to recall them for further cross-examination. And also, in the meantime, I also moved before you, my lord, to quash the proceeding on the ground that they have married and leading a happy marital life. And in view of the latest decision of the Honorable Apex Court, my lord wouldn't entertain my application. That's why I have come up with an application to recall PW 1 and 2, who are the
What is your age?
My lord, I am 25.
You are 27.
My lord.
The girl says,
My lord. Girl is then she was 17 plus. Now she is 25.
25. They are married.
My lord.
Blessed with the child.
My lord. On that ground, I also moved an application to quash the proceeding. But in view of the latest decision of the Apex
No, I have passed a recent judgment.
My lord has also passed on the
Just check it up.
Yes.
That can be helpful. Check it up. I'll put it next week. Huh?
My lord.
Okay. Next week.
My lord.
Because both of them are major. They
Yes,
married.
yes, both of them have married.
There is a child.
My lord.
Just check it up.
My lord. May I pray one thing, my lord? The case has been posted to 25th for judgment.
25th for judgment.
Yes, my lord.
That's another problem.
That's
At this stage, I can't scuttle the.
No. Subject to orders of this honorable court. Till then. Otherwise, my lord,
What
my
can I
purpose
do?
shall not be fulfilled. Till then, my lord.
No, the evidence has come against you.
Yes,
I can't
that I don't dispute, my lord. Because they have tendered their evidence in the year 2019. However, they got married in the year 2021. That is the tragedy.
That's the tragedy now.
So, my lord, the judgment has been posted to 25th.
Judgment I can't stall.
No, that I cannot say, my lord.
I can't stall the judgment. You have moved application 311.
My lord.
That has been rejected.
That has been rejected. And that I have already submitted. That's against that order I have come up.
So, give some judgment, something. How can I see? The problem is the witnesses have deposed against you. And the court can't be a party to recall these witnesses to, depose in your favor now.
Yes, that's
You are now in a very difficult situation.
yes. That's true, my lord.
I'm just passing it over, just check it up, what can be done. You think over.
My lord.
And we get some judgment, we'll see what can be done.
They-
When the judgment is scheduled to be
25th, my lord.
25th.
25th.
Uh, 31 item.
My lord.
Where have you said that you have married? Any proof?
My lord, that's why I have made both of them parties in this case.
No. You have you given any proof?
No, I have not given. I have simply avoided in my application, my lord.
That's the whole difficulty. Then I'll have to issue notice. There are so many problems. There should be a joint petition.
My lord, I was expecting the OP to appear today because he couldn't come because he is on his way to.
Then pass it over. We'll see.
Beg your pardon,
Let him come.
my lord.
Either you should have filed a joint petition.
Yes.
That we have married or something.
Yes,
That you have not done. Proof of marriage you have not given. Witnesses have spoken against you.
My lord,
Judgment is about to be pronounced.
can it be
At this
taken
stage
on
you are coming.
24th, my lord?
Huh?
Can it be taken on 24th?
You will do 24th.
24th, my lord.
That's the problem with you.
My lord.
Place on record the proof of marriage.
Yeah, let them appear
Place
on
and
that.
record the proof of the child born from the wedlock.
My lord, issue notice to the opposite parties number 2 and 3 so that on 24th they will also appear.
Issue notice
My
to
lord.
opposite party number 2 and 3. See,
Two
the
and-
problem is if you don't protect this, their life is spoiled.
Yes, yes.
He will be definitely convicted.
Yes.
101% convicted.
My lord, I know the
Delayed it what?
My lord, item 77 compromise matter, my lord.
I'll take it up. I'll just come. The evidence is going on.
My lord,
Evidence is going on. What is the problem?
my lord, cognizance was taken on 22/6/2021.
When charge framed?
Charge.
framed on 30th June 2020.
21. Only one witness is examined.
Only one witness, after no PW notified till date. No.
Why? What is happening? Are you not appearing or what?
My lord, I am appearing.
How many accused are there?
Accused, 4 accused.
Somebody must be absconding or something.
No, this is two groups. The Mohima Olek. Two groups. Two groups is one is the Bakaladhari Mohima Olek, and the Kaupulidhari Mohima. Two groups fight each other for a piece of land.
Madam, petitioners by invoking the inherent jurisdiction of this court under CRPC, seeking a direction to the trial court for expeditious disposal of the trial emanating from the Gondia PS case number 31 of 2020-21. The next program, the FIR has been registered in the present case on 8/2/2021. After investigation, charge sheet has been filed on 3C for release commission and 3 subsequent thereafter. The trial court by this order dated 22/6/2021 took the cognizance of the offences punishable under section order under section 294, 506, 109 and 34 IPC. Charges have already been framed. When the date charges, although
30th June 2021.
Although the charges have already been framed on 30th June 2021, but out of 11 witnesses, only one witness has been examined by the prosecution till date. Therefore, the petitioner is agreed and submits that there should be the court will give a direction to the trial court to dispose of the conclude the trial as expeditiously as possible. The petitioners, you are the accuser.
Yes, madam.
The petitioners are the accused. They have constitutional rights to prove a speedy trial. Hence, the prayer made by the petitioner deserves merit. Accordingly, the trial court is directed to do well to see that the trial is concluded as possible. Yes. Yes.
34.
May plus. Convene the convenience as well as the entire criminal proceeding. In fact, the petitioner is the in charge of the headmaster, cause of the retirement. Informant is the assistant teacher. Allegation or tribal by magistrate 294, 354, 354A. Lordship, see the FIR at page 15. Allegations have been made that no duty was assigned to her. In her absence, her pay was held up, and no duty was assigned. Most of the allegations are linked to the official duty. And now the petitioner is 59 years. Let me notice me.
No, outraging modesty is
my lord, kind of a glance page 50.
354D, 354A.
That has been registered and cognizance has been taken. Allegations, my lord, kind of class.
Let's see the statement.
Again, page 15, my lord, kind of class. Victim herself lost the affair.
No, statement. Come to the charge sheet.
Say affair page 15 that.
Forget about FIR. Now,
FIR lost by her. FIR lost by her.
Let us see the charge sheet. What has come against you after investigation? What is your name? What is your name? Your name is? What is your name?
Ravi Prakash. Her name is
Ravi Prakash. Let us see. Pranati Mahapatra is the informant.
She lost the herself by the affair.
lodged by her and allegations of 2023-24 ଗୋଟେ continuously process ରେ allegation ଟା ଦେଇଛନ୍ତି। ମୁଁ ପୂର୍ବତନ ପ୍ରଧାନ ଶିକ୍ଷକ ଶ୍ରୀମତୀ ସଙ୍ଗୀତା ମହାନ୍ତିଙ୍କ ସମୟରୁ ସ୍କୁଲ ଏମଡିଏମ ଦାୟିତ୍ୱ ରହିଥିଲି, କିନ୍ତୁ ମୋତେ ମେଣ୍ଟାଲି ୱିକ୍ କରି ସେ ପ୍ରେଷ୍ଟିଜ କମାଇବା ପାଇଁ ମନ ଇଚ୍ଛା ଏମଡିଏମ ରୁ ବାହାର କରିଦେଇଥିଲେ। ମୋ ଆବସେଣ୍ଟରେ ଷ୍ଟାଫ ମିଟିଂ କରି ମୋ ବିରୁଦ୍ଧରେ ଡିସ୍କସନ କରିଥିଲେ। ମୁଁ ତା ପୂର୍ବରୁ ବିଦ୍ୟାଳୟର ବିଭିନ୍ନ କାର୍ଯ୍ୟକ୍ରମରେ ସଂଯୋଜନା କରୁଥିଲି, ସେଇ ଦାୟିତ୍ୱରୁ ମଧ୍ୟ ମୋତେ ହଟେଇ ଦେଇଥିଲେ। ମୁଁ ସ୍କୁଲର ନୋଡାଲ ଅଫିସର ଦାୟିତ୍ୱରେ ମଧ୍ୟ ଥିଲି, ସେଇ ଦାୟିତ୍ୱରୁ ମଧ୍ୟ ମୋ ଅଜାଣତରେ ବିନା ରିଜଲ୍ୟୁସନରେ ଛଡେଇ ନେଇଥିଲେ। ଏସବୁ ତାଙ୍କର ଷଡ଼ଯନ୍ତ୍ର ଥିଲା, ଯାହାଦ୍ୱାରା କି ମୁଁ ମାନସିକ ସ୍ତରରେ ଦୁର୍ବଳ ହୋଇ ତାଙ୍କ ଇଚ୍ଛାକୁ ପୂରଣ କରିବି ବୋଲି ଭାବୁଥିଲେ। ଡିସେମ୍ବର 11, 2023 ସୋମବାର ଦିନ ମୋର
harassment in the workplace.
ସପ୍ତମ ପିରିୟଡରେ ଷଷ୍ଠ ଶ୍ରେଣୀର ଲାଇବ୍ରେରୀ କ୍ଲାସ ଥିଲା, କିନ୍ତୁ ପିଲାଙ୍କୁ ଧରି
Thereafter, she applied Indian on Monsoon date. She joined our bench. Monsoon on PC Saturday, the other solution at the prayer class. She was present at that time. Sri Kanungo appealed to her in the option market and dominated her in presence of the staff.
other staffs.
Sri Kanungo tortured the complainant mentally from time to time in different places. Appealed to her in the option language before the staff and students. Thereby, she lost her modesty in this connection. She reported to
Was there any Pisaka committee?
No, not approach to any authority, nothing else.
Issue notice. Why don't you settle?
Yes.
Issue notice.
Retire hobo 59 years.
55.
I is there.
Yes. Yes, settle. Yes.
I is there.
You bring your first food. Yes.
35.
So the appearance will be let. Appearance.
What reality नहीं ना फिर नो करे पूरा समीशन आसुनी आप करेंगे।
38.
May I present? The Belgium matters, the enrollment issued matters 3/8/2019 matters due to illness matters, he could not appear this court matters, and he was in a bail matters on 16/12
December 2017.
6 December 2017 is the
Bail.
bail. And
August 2019.
NBW 3/8/2019 1000. Yes.
39.
May I please, your lordship? My lord, on behalf of Mr. Pal, NBW suit 10/12/2024.
Bail on
1st November 2016.
16.
16.
500. Yes.
40.
May I please, your lordship? On NBW suit 28/2/2025.
Bail on the 21 September 2022.
Okay. 500. Yes.
Each 3 persons, my lord. 3 petitioner.
Yes. 41.
3 petitioner.
Huh?
3 petitions.
500 each.
Each. That you know, yes.
Oh, let's
41 na?
May I please, your lordship?
41. Yes.
41.
May I please, your lordship? NBW is not 7/10/23, my lord. Released by court below, my lord, bail.
Well, no date has been mentioned in para 2. They have mentioned the release date.
500. Oh, 500. Yes.
42.
Obliged.
NBW issued on 19/2/2024, my lord, page 7, next one. And release on bail on 2/11/2015, and it's 2 page 7, my lord.
24/10/2011 is the 2015 is the bail.
Yes. Page 9.
19/2024 is the NBW.
Yes. Page 7.
What the dates? Tell with clarity. Why don't you tell?
My lord, page
1 minute.
page
1
7.
minute. 1 minute. Yes.
24th October 2015 is the bail.
Bail.
19 February 2024
Okay.
is the NBW.
Okay.
Yes.
43.
43 3rd April 2014 is the bail. 4th December 2024 is the NBW.
Okay. 500. 500.
44.
NBW 22/7/2024 and bail on 18/1/19.
Okay. 500.
45.
45, my lord, on dated at 25/1/25, I was on interim bail, my lord, and directed to surrender, but I could not surrender, my lord. Communication gap, my lord.
NBW 10/2/2025. 500.
You are an interim bail, man.
Yes, I was on
In
interim.
court surrender now. Yes.
46.
NBW was issued my lord 18 to 2025. Bail was granted 10/6/2019.
25. 500. 500 each, huh? Each. Each one.
My plea, your lordship. NBW issued on 21/6/2019, my lord. The petitioner was on bail 16/1/16, my lord.
1000.
48.
48, my lord. NBW issued on 4/2/2019 on bail on at just for my lord.
1000.
49.
My lord, NBW issued on 4/2/2025, my lord. But petitioner was not on bail. He was on interim bail, my lord, and could not surrender. That's why NBW issued, my lord. My lord, which person released on bail, my lord? I'm just praying.
500.
First of second of parity may be granted.
500. 500. Yes.
50.
Yes, on the section 32, it is attended on the date of judgment. Due to illness, the petitioner was admitted at Bangalore Hospital for 4 months. That's why he could not.
On the date of pronouncement, on the date of pronounced judgment, she was found absent, my lords.
She was admitted in Bangalore Hospital.
Anyway, thereafter, NBW was issued on 27th.
Date of the pronouncement of judgment remain absent, and NBW has been issued on 27/2/2025, and
27 to the
28th of this month.
Ma'am, pardon.
28th of this month.
28th
Of this month, you appear.
Pronouncement judgment.
30th. Say Bangalore hospital is
30th would be holiday, na? Because you try to understand, the trial court has to give every month so therefore I'm asking you to at least he'll pronounce the judgment at that day.
Yes.
So in the month of March, it can be counted.
Yes.
29th.
Therefore, I'm giving.
Correct.
28th I'm giving because 29th is a Saturday. Thereafter 30th.
29th is a holiday because by election. 28th, my lord.
28th.
28th.
20.
But the order passed one is.
Set aside subject to.
Obliged.
AEW is set aside, subject to petitioners appearing before the court
honor before 28th.
28th. Honor before 28th without fail. Yes.
Obliged.
51.
My lord, on NBW issue 10/9/2024. Order dated 23/4/2027.
20?
2007. Bail 2/3/2007.
2007. NBW ODH for the established. Okay. 500. Yes.
Okay, my lord.
52, my lordship, FR was registered on 25th of 10/2010. NBW was issued on 5/4/2024.
At the stage of commitment, my lord. Lord and Session Judge.
500. Yes.
53.
May I please, my lord?
Yes, sir.
An IA was filed, my lord, in a writ petition, which was dismissed with a leave to revive the petition if the suit is, my lord, in the meantime restored. For your lordship's kind consideration, lordship may kindly turn to order dated 5/10/2021, order number 6. 5/10/2021.
Order number 6. Yes. Yes.
Here, my lords, the order, my lords, your lordship would appreciate. Order number 8 in WP 27112 of 2013. Paragraph 4 notes. In view of the dismissal of the suit, the receipt petition is not maintainable. Accordingly, this.
Where are you reading?
Lots paragraph 8. Page, my lords.
No, you first refer to.
I referred to your lordship's order dated 5/10.
You brought LRs on record?
5/10. Sorry, my lord.
You brought LRs on record.
I brought LRs on
yes.
record.
Thereafter, what happened?
Thereafter, my lord, what has happened, my lord, in this case, I filed an application for revival of the suit. Pursuant to your lordship's order dated 5/10/2021, my lords, the suit was restored. Thereafter, my lord, I have filed an IA for revival of the writ application, my lords. And this is pending before your lordships, and the lordships said we should notice, and my learned friend has also appeared, my lord, for the opposite parties, my lords.
What are you seeking in this writ?
Lord, see, in this writ petition, my lords, I had filed an application for stay of the suit because 2 writ applications against the Consolidation Commissioner's consolidation order are pending, my lords. The link, my lord, is in my application before the Consolidation Commissioner. The noting is Beain Khadri Sutre Dakhal. To delete that, I filed a writ petition. The opposite parties have filed a writ petition challenging the entire order, where the Commissioner has come to a specific finding that I am the recorded owner and the possession is there, my lords. The suit was filed, my lord, first for permanent injunction. Subsequently, notwithstanding that, they continued with construction. Thereafter, declaration, my lords, permanent injunction. Thereafter, my lords, the suit was amended to one of recovery of possession, declaration of title, and so on and so forth. So since these 2 applications, so especially the application of the opposite party against the Commissioner's order regarding their title, my lord, was pending in the writ petitions, I filed an application under section 10 read with 151 for stay of the suit, my lords. That was dismissed.
It's a contingent now.
It's my lord, it's a contingent application. So unless these 2 writ petitions are heard, I had prayed for stay of the suit.
What do you say? Who is it?
Yes, I am for the opposite. What do you say, sir? That's right. What so far as suit is concerned, my lord. Suit
You
is of
are
the
connected your original suit of title suit to a recovery suit now. Recovery of possession. Okay, recovery of possession.
Suit is of their 1998, my lord.
That's right, but see, unless this writ petitions are decided,
all those. One is of 2003, another is of their 2013. 2 writ petition is pending.
where are the writ petition? The 2 writ petitions
The 2 writ petitions are
WPC 8245 of 2003.
listed today.
no, it's not listed. Only
And
my
is the writ petition and hear it and finish it up.
Yes.
Otherwise, they will never end. 1988 suit.
But in the meantime, will lordship may protect me? No, the suit should not proceed.
Suit is not proceeding as it is.
No, my lord, it is proceeding every day. Each day and 21st is the next day. Because of your lordship's interim order, it was on 9th. It has been posted to 21st. 9th of March. Interim order to continue.
Where is that? 9th of March.
Last order, your lordship may see. I stand corrected.
19th February.
I'm sorry, 19th January.
Interim order passed earlier, sir, continue till next date of hearing. Interim order is there.
No, but interim order, my lord, is that I have to file an application for adjournment, and thereafter it will be considered by the learned court below.
That's right.
So instead of that, my lord, it becomes.
Somehow you are getting an adjournment.
I'm getting an adjournment. But unfortunately,
the 88 suit, you are getting an adjournment. You tell me the other suit number, I'll list it and hear it.
No,
that is the only solution.
That is WPC 8245.
Right, release this writ petition along with the writ petition number. Don't show for final disposal. On a particular date, during hearing. It's a 1988 suit. How much?
The problem, my lord, is there has been a series of deaths of the defendant.
I know.
And that is the problem. LRs and all that. And the LRs, my lord, and the daughters, my lord, have to be brought on record. So the entire thing was beyond the control of the.
I'll decide both the writs so that you need to move application under order.
So far as that 2 writ petition is concerned, that is against the consolidation order. Assignment is different.
But the problem is, it is contingent. You can't, go
ahead with the suit.
Yes, without deciding the writ petition.
There can't be a cleavage between all the 3 writ applications.
So this writ petition along with the writ petition for hearing, the interim order passed earlier shall continue. It is made clear that no further adjournment shall be granted, and both the writ petitions shall be heard on the next date of hearing. Get ready and come and.
In the meantime, lords, your lordship may.
Interim order continue. Interim order.
Your lordship has fixed a date.
Adjournment by filing an application there.
That interim order.
No, sir, your lordship has fixed a date for the hearing.
I'll just adjust and fix a date so that I can hear.
Yes.
Sometimes in April, if your lordship.
Yes, April. Second week.
Greatly. Can it be after?
Get ready with the written note and all.
Already filed. Already that is.
Okay, may I just pray any date after 9th of April?
9th February.
No.
10th February.
10th or 15th.
10th April, sorry, 10th April.
10th or 15th, whatever date is convenient for you.
10th or 15th?
10th or 15th. Any date
can be 15. 15.
Greatly obliged.
15 at 3:30.
My lord, may I
I'll take
one
up.
thing? If my lord, in trade will file the notes of argument, will material exchange in the meantime.
Yes, sir.
Yes,
You also file.
Yes,
I'll give the advance copy so that.
Yes,
we-
so it will be convenient for the court also, will not.
Yes,
So that
easy. Hoji.
greatly obliged, me. Yes.
54.
There is a application for further continuance of the stay order passed in miscase number 769 of 2016. My lord, the application was filed as per the as per the direction of the Supreme Court in Asian Resurfacing of Road Agency Private Limited, my lord, but which was modified in criminal appeal number 3589 of 2023. My lord, my submission is it may be deemed to continuing, and my lord may fix a date for
Which interim order you're talking about?
my lord, interim order dated 19/5 to 2016, my lord. Passed in
19/5, 2016.
my lord.
19/5, 2016. Are they totally in RFA state?
My lord, RFA
2016 is operating. What is the main matter you tell me?
my lord, the main matter is regarding
What are you seeking here?
my lord, I'm challenging the order of the appellate court passed on date order date 29/3/2016.
There is that order 29.
Additional District Judge Bhubaneswar in deferring the consideration of the petition filed by the petitioners for directing to the appropriate authority to cause production of certain documents which are to be sent to the forensic department for examination of the handwriting.
I am for the respondent number 1.
Yes.
I mean, pardon. Well, there is 3 FLP, my lord. One is executed in minor and 2 are others. ଯୋଉଟା 88 ମସିହାରେ ଯେ ଭେଣ୍ଡର ଯେ ଭେଣ୍ଡର କରିଥିଲେ ସେ ମରି ଯାଇଛନ୍ତି ତାଙ୍କର ଥମ୍ବ ଇମ୍ପ୍ରେସନ ଆଉ ସିଗ୍ନେଚର as per section 73 of evidence act available ହେଇପାରିବ ନାହିଁ ଯଦି available ହେଇପାରିବ ତାଙ୍କର ଫରେନ୍ସିକ ଲ୍ୟାବକୁ କେମିତି ଯିବ ସିଗ୍ନେଚର କେମିତି ଇଏ ହବ and they are praying for additional evidence putting additional evidence. Order 41 Rule 27 denied at the time of appeal. Additional evidence cannot be produced. Yes, ma'am.
Only for this issue, the matter is pending in 2016.
Yes, ma'am.
The argument will dispose it of. What is this?
Give another chance, my lord.
What chance? Yeah, small issue. I can decide within 2 minutes. 2016 it is pending. I pass it over, get ready and come. There is nothing in this matter. See, the impugn order is only 3 lines. 3 lines impugn order. There is no reasoning, nothing. Just see, come to page 37. Page 37. 2019/5/2016, you have taken the stay of the further proceeding in the appeal, first appeal, and it's going on and on and on.
My lord, after a long gap, it has been listed. My lord, my list.
So that's the reason I want to hear it and finish it up. I pass it over. You read it. Pass it over. Sorry? Young man, let him get things right, no? So, when do you want to tell you? But you have to argue.
My lord.
Just see order 43 and the section 73 of evidence check. That's all. You tell me the name. You tell whenever you want.
Monday, my lord.
24th. Let it 25th. 25th. Okay, get ready and come. 25th.
Obliged.
Yes.
55.
55 is covered matter.
Yes.
By
delay.
Delay. 1101 दिन delay.
Yes.
1101 दिन.
FAO delay.
1101 दिन FAO delay. Review.
1101.
1101. 312 दिन
review delay.
312.
312
money.
FAO delay 1101. Review delay 312.
Yes. I may please, your lordships. Whereas here is a application CMAPL members seeking restoration of the writ petition, that is WPC number 31386 of 2011 members. What has happened, members? While the case was pending, members, due to non-appearance, members, of the counsel for the petitioner, the case
how much delay?
Again, delay होची actually dispose हो ही 24/4/21 से मैं फाइल करची 19/7/23 रे 2 वर्ष delay.
Notice
That beyond the नहीं notice जाइए ना notice जाइए limitation notice हाँ.
What is the explanation?
Matters. Now I am more than 8 years old, married. And what has happened, I am suffering from old age elements, and I am also having the documents, medical certificates, the prescriptions are also there.
You just see your condemnation of delay application.
Matters.
Just see what have you written.
Yes.
What is the explanation?
Yes.
For 2 years explaining it.
Matters. That the petitioner having
Single explanation. You told me.
You also make only see that
but you show me the application certain reason.
Section 5 will be read with the CML application itself. As because humbly submitted that
the interest of justice condone the delay. That's the sufficient reason.
Matters as because matters I was suffering from ailment.
And where have you said? You show me.
Yes. In matters, let me kindly have a glance. The paragraph 2 of my CMAPL application. I have started in the CMAPL application. Yes, yes, CMAPL application.
In the condemnation of delay, you have to give sufficient reason.
Yes.
You only have said that he is a very good case.
Yes.
Therefore, condemn the delay. See the concept of sufficient.
I dismiss it. No, I CMAPL. I have started. Yes.
Not delay, you don't say.
No,
okay.
Yes.
Okay. Which paragraph?
Paragraph 3, 3. Paragraph 2, the conducting advocate remained absent. Paragraph 3, such honorable court time beyond the control of the petitioner.
Paragraph 3, 2.5 lines. For non-attending report, the time was called beyond the control.
Beyond the control. Because he was 80 years old and he was suffering from medical ailments.
You have to give sufficient documents.
Yes.
Can't condone like
that.
Can't condone like that. You want to file a better affidavit, file it, but I can't do it.
I can file an affidavit.
Clearing delay, every day.
Yes.
At least overall,
yes. I have sufficient documents to that. I'll file.
No document file, nothing.
Yes. I'll file. Let me kindly call this matter on Monday.
Matter is heard. Now, matter is heard. The petition is suffering delay for about 2 years. I have perused the application for condemnation of delay moved by the petitioner. The application is very tough, any explanation. Confronted with that situation, that counsel for the petitioner seeks an adjournment to file a better affidavit to explain sufficient cause of the delay in filing the CMA application. Lease the matter after 3 weeks.
Date yours.
They'll give it date.
Your Lordship, in this case, 5 CMAPL, because 5 writ petition arising out of same issue, similar, all the parties belong to one family. So, due to sole petitioner Gopal Panda died in 2021. But in 2022, on 2014/9/22, this was dismissed because I missed the list. Thereafter, I contracted work because we could not contract because the sole petitioner died. Then, my lord, he came and filed the petition. They also private parties, my lord, already appeared.
Cause of the delay.
Delay सेटा देइछि मु cause of delay.
How much delay by the way?
581 days. 581.
There is no sufficient cause. Your Lordship, there is no sufficient cause in the delay petition for condemnation of.
Let us see the application. Para 3.
Your lordship.
Read it.
Inadvertently, when the matter was listed for admission 49/22, the petitioner counsel could not appear before this honorable court due to missing of the list. The petitioner came to know from the private opposite party when they declared that the petition filed by the father, their father, has already been dismissed because sole petitioner died by that time. Thereafter, the petitioner contacted with the council and were instructed to file a restoration petition.
There is no date, nothing.
My lord,
General explanation.
My lord, the petitioner counsel had also absolutely no knowledge regarding.
Shall I put 2 terms and condone the delay? Shall I put 2 terms and condone the delay, or you have objection?
This list belong to same family.
The objection.
Objection to what they chale.
So,
Lordship, the objection.
what have you said?
He is appearing for OP member 4. Only he has filed objection, but the other opposite parties have not filed any objection to my
Objection is it flag?
Yes, yes. Let us see.
He for OP4. Meritorious decide
Lordship, only my objection is that no sufficient cause has
been that ground.
Para 5, your Lordship, of my objection.
Let's see. Yes, what do you say? Mr. Poda.
Condone the delay. Genuine ground.
As your Lordship.
I'll put 2 terms and how much cost will you pay?
गरीब लोकटा जहाँ कहबे ये
500 I can't then on the ground of no ground I can there is no sufficient cause.
Then as your lordship.
Not at all.
Then as your lordship.
For the petitioner has where is that order by which it is dismissed for default? Where is that order?
14/9/22. 14/9/2022.
Where is that order? Where is that order? Have you filed? I don't know. Why have you not filed the order by which it is dismissed in default? You want restoration, recall of that order is not there.
Sorry, my lord.
Where is that order?
Sorry, ଆଉ ଗୋଟେ ଦିନ ଥାଉ ଟିକେ ଦେଖି ଦଉଛି ଯେବେ ଏ ପାଣ୍ଡେ ଥାଉ.
After 4 weeks.
Your answer next week.
How you file these petitions? I don't understand.
My lord.
You are seeking recall of some certain order.
Very sorry, my lord.
Except that order, everything you have filed.
Oh, bro.
How is registering entertaining this petition? I don't
It's
understand.
very unfortunate, my lord, because it has not quoted in my petition also. This is very.
That it is
I'm
dismissed
very
in
sorry.
default or dismissed on merit. How do I know?
Your lordship is right. Your lordship is very correct.
And how this registry is entertaining this kind of petition?
Say more what a Xerox.
And this is pending since sheet.
Your lordship is correct.
As it is, you filed after 500 days delay, and this is the petition. Why should the court will give you delay?
Very sorry.
I should dismiss it. As simple as that.
Petition.
I should dismiss it on the ground of delay.
Lordship, that along with rate petition, it has come.
No, you have to file the order.
Your lordship. Your lordship. Sorry, my lord.
I'll keep on searching read petition.
No, my lord.
Why don't you say go to the registry and put the order? You write it there. I'll go to registry.
Lordship is correct, my lord.
What is this? It is there in the read petition. Go and see. which has already been
I
dismissed.
should have verified that, but because it is CMPL, but I have not verified. This is
are
my
four
fault.
weeks,
madam.
These are 4 weeks. Yes.
No election you.
58.
June release.
I'm sorry, madam.
An application for modification of order dated 15/3/24, my lord. In this case, my lord, your lordship directed the petitioner to be released on bail. Condition number 6, my lord. The petitioner shall furnish 2 local securities and shall appear before the IO Narcotics Control Bureau Bhubaneswar once in every month, and shall appear before the learned court in session over the matter on
Condition
each date
number?
of post, my lord.
Condition number, which condition?
Condition number 6, my lord. In
Where is
para
that?
6.
Where is that?
Condition number 3.
Order dated
15. 15/3/24, my lord.
15/3. Okay.
15/3.
Condition number?
Condition number 3, para 6. Double 2 है 3 हो.
What is this? Jyoti. Para 4 for para 7. Receive. ये अपने पर्ची का
3 होगा कहता है 2.
Where is the order? I know, but this order is now.
Let's see.
15/3/2024. Order just see. You upload करते हो. नहीं see. 8 page 4 है. 8 page 4 है. Direct traffic भी 8 to 8. Model page 9.
Standing.
How have you got this?
Para 3, my lord.
You where from you got the certificate copy from this?
Certificate.
But it's not uploaded.
My lord, after release on bail, I applied and I received certificate copy.
But he got how he got the certificate copy?
The High Court website, the copy is there.
High Court website copy
High
is
Court
there.
website copy
Copy
is
is
there.
there.
No, it's not there in my file. Therefore, I want to upload. नहीं सर्टिफिकेट कॉपी मांगने को हार्ड कॉपी दिया मुझे
डाउनलोड करेंगे
डाउनलोड कर इट आप इतना ही
डाउनलोड से इट डाउनलोड स्कैनिंग
just check it out. Yes,
Para
petitioners have
3,
published
condition is
two
personal
proposals.
appearance of the petitioner once in every month before the IO NCB Bhubaneswar, my lord. That may kindly wiped out as because charge sheet has already submitted, police paper has already received, petitioner appearing before the learned court below on each
So
date
you
of
are
posting.
outsider. You are outsider.
Yes, my lord.
You are outsider.
I am appearing before the investigating officer, narcotic control bureau, my lord, and also before the learned court below, my lord, on each date of posting. Now,
where
in the meantime, charge sheet submitted, PP has already been received.
Yes,
I'm appearing on behalf of the NCB.
NCB, my lord.
What do you say?
Section is that out of the last 3 dates, he has not appeared twice. So the condition is that we are not fixing any date for him to appear. Any date he appears on the trial, which is fixed every month, he can come and appear before the NCB. He did not come separately on a date.
Separate date to about trial date is different.
No, you have not complied the order so far.
The complaint, my lord.
That's what he says.
Section is that he has not complied. They are not appearing regularly.
Appearing, my
With
lord.
an anticipation that I'll allow it. You have not stopped going there.
My lord,
You
appearing.
stop going before the application is allowed.
My lord, petition is appearing before the learned court below, my lord.
That you have to. You are not
On
doing a
each
service
date,
to the
each
nation.
date, also appearing in the NCB. My lord, order was
That's
passed on.
what he says that you are not appearing.
गोटे डेट रे कोन हेतो मु आ जाननी कोन हेतो के गोटे डेट जदी कोन हेतो so with गोटे डेट there charge sheet submitted, PP has already been
The
received.
conduct is such then
Charge sheet submitted, PP police paper has already been received.
that I understand. But if the order is there till the order is modified, you have to comply the order. And you are from West Bengal. If this is your attitude, I'll waive this, then thereafter you will evaporate.
No, my lord.
You will not appear
Before
in
the Lord Court will issue and
because of this condition, at least you are coming and appearing before the trial court. If I waive this condition, you will not come to the court.
Well, I am appearing, my lord.
Then NBW will be issued and everybody will keep searching you.
Then appearing before the Lord Court will on each date, my lord. Each date. Police paper has already been
So
issued.
far you are appearing because of this condition. Because of this condition, that deliberately this condition was incorporated in the order. If there would not have any objection, I would have done it. But there is an objection now.
The date code date appear for nothing.
The point is that your lordship's condition is two parts. One, he has to appear every month before the trial court, one before the IO. We are saying when he appears in the trial court, let him appear on the same day before the IO.
Right. Right.
Assembly order may pass.
Petitioner is seeking modification of the order dated 15/3/2024, whereby the petitioner has been admitted to bail with a condition that he shall appear before the Narcotic Bureau Bhubaneswar on every month. Every month, apart from appearing before the trial court in session of the matter, session of the trial of the case in which bail is presented.
After receiving a police paper, not necessary.
Submits that appearing before the Narcotic Bureau every month and simultaneously and also appearing before the trial court is creating serious hurdle for him because he has to travel twice a month. Moreover, the charge sheet has already been filed.
Police paper has
appearing before the Narcotic Bureau may not be necessary. Letter counsel for the Narcotic Bureau submits that despite the condition, the petitioner has been a defaulter in appearing for the Bureau since last 3 occasions. Be that as it may, the trial, the petitioner shall appear before the Narcotic petitioner is bound to appear before the trial court on every date of hearing. After the every date of hearing, the Narcotic Bureau shall fix it. Whenever the petitioner is appearing before the trial court, he shall also, on the same day, he shall also appear before Narcotic Bureau. With this modification, the application is partly another. Whenever you come to the trial court, you go and appear.
Yes, ma'am.
My lord, next item also same.
Next item similar, but the modification of order data 3/5/24.
3/5/24.
Is he appearing for the? Is he appearing or not?
He is appearing, my lord, but actually we have already filed a CRLMA 114 of 2024 to challenge.
Last 3 periods only.
In this case, my lord, he is also appearing.
He is
appearing, therefore I am not writing that.
Item 60.
Much obliged.
May it please your lordship. Your lordship was directed to service the notice through IIC, but not received the
Visra police station.
Yes.
Again, it came unserved, my lords. My lord, I would like to submit a certified copy. Yes, no,
The report has not been received.
second time notice went. Again came unserved.
IIC couldn't say.
No, my lordship.
Well, she is residing on the same very address, my lord.
What?
They have not given me any report, my lordship. Today morning.
Yes, get the report.
No,
you got the report.
No, they have not.
In the noting, it is mentioned.
Mentioned to serve the notice through IIC, but IIC has not given any report.
IIC has
The
not
status of the
given
notice.
report.
Okay.
Let us read that. Right. On 31/1/2025, the IIC Mishra police station was directed to serve opposite party number 2. This is one appearing for the state submits that she has not received the instruction from the IIT, hence seeks an adjournment. These matters after the 2-3 weeks. The interim order passed earlier,
I may be pardoned, my lord. Your lordship may kindly bear with me for a moment. My lord, my difficulty is that on the last occasion, your lordship directed that I may be permitted to quote. In the meantime, learned counsel for the petitioner may move application before the learned court below, seeking adjournment owing to the fact that the matter is sub judice before this court. My difficulty is there, my lord, the counsel who was conducting my case, he is now appearing for the wife. And I have submitted the
Not
document.
appearing.
Not appearing, not moving the application, and the person is resident of Jharkhand, Dhanbad.
So what will I do?
No,
I
no,
create a counsel.
no, my lord. Stay application is still pending.
Very funny.
Unless and until
Your counsel is not moving application, therefore I will put it.
My lord,
You engage
may
someone else.
kindly see my difficulty because I am not able
You may have a
to move to
difficulty.
Raurkela.
How the court can court is concerned about it.
May be modified that stay. But this is not the ground, my lordship.
Very.
Because
You engage better. You have to engage someone.
I have engaged, but they are not
Remove it. If it doesn't move up.
They are not cooperating. I am submitting the original certified copies, my lord.
Show me where she says that.
Signature of in the GR case, the husband, the conducting counsel is the same who is appearing in the CRP case. The CRP case, I have submitted the certified copies, my lord.
It's all right. You change the lawyer.
I have changed, but they are not moving the application. They're not cooperating at all because the person is outside resident.
Jharkhand, wherever you want to go.
He is an outside, my lord.
You have a grievance against your own lawyer. What can I do?
Some modification, my lord.
Entry order passed on 2/12/2024. Shall continue.
My lord, kindly consider this.
I have passed some order. How can I modify it? Service is not complete. What is
I may be permitted to file a modification petition then. If your lordship allows.
You file application stating those things, I can record and change.
Deeply obliged. My lord, if the notice can be sent through email also.
No. Let the IHC do it.
Oh, yes.
Email ID you have.
Yes, my lord. Email ID है
Hey.
check करके बताते.
Do you have or not? Email ID.
Right now, I don't have.
If you have, I can pass that order.
No, my lord. I will first inquire. I have to take instruction.
Get that.
Yes, lord.
Now, liberty is also granted. And Mr. Rajgaria, that counsel for the petitioner submit that she may be permitted to serve opposite party through email. Through email. It is open for the petitioner to serve opposite party number 2 to email as well. Apart from that.
Deeply obliged.
61.
Lord, similar. One IE has been filed for a modification of order dated 16/1/2025, Miller. Due to my mistake, Miller, Lord, it will be ST case number 204 of 2015 with Miller, GR case number so and so, PS case number so, and assistant session judge Chhatrapur in place of additional session judge Chhatrapur.
So only this additional word has to be replaced with
ST case number and assistant session judge. It will.
Where ST case, where have I written?
Milord, in
which para?
Cost title as well as paragraph 1 and 5.
But in the order, ST case is not written anywhere. Where have I written ST case? I have not written. GR case?
I don't know. It will be, Milord. ST case. Khali GR case thila, ebe ST case haba seta.
Okay. Okay. Hello. ST case कर दो, additional जगह assistant कर दो. Okay.
62.
Paragraph 1 and 5 also. Cost title and paragraph 1 and 5.
Cost title.
Oblige.
Correcting the name of the village and the police station in the cost title.
Sorry. Modification?
Only correction of the name of the village and a police station in the cost title.
But in the order, I have not written anything.
That no, only cost title. Cost title is the Ghana ta police station ta
Ghana ta कौन लिखियो? Village सोलापुर.
सोलापुर इनफिट ऑर्डर थिला पुनी करेक्शन करिक देले सेटा हबो टोनिया बंद अंडर पुलिस स्टेशन बळंगा बट इट इज पीएस बळंगा दैट्स रॉन्गली सोलापुर अंडर पुलिस स्टेशन बोर्ड.
Where is that order? Is the order? Where is the impugn order? See, you have to correct in the trial court record, not in the High Court record. In the trial court, it is written same.
Yes, one second.
Solapur go.
I filed in the IA.
Where? Where?
Annex to 1.
Where have you filed? See, this mistake is there in the trial court record. You have to correct that.
I have already corrected 1 second file in the IA.
You corrected there.
Yes.
Okay, right. Land Council for the
Corrected
particular seeks modification for the seeks a correction in the cost title of the petition, changing the name of the village to be name of village. He submits that the error has caused because in the trial court record as well, the name of the village is being written as Solapur PS Go. Go. He has already moved application before the trial court for getting correction of the same. Accordingly, the present application is moved for correction of the court title. The application is allowed and correction is allowed. Yes.
And the extension of time surrender.
Extension for the yes.
63.
Millard, I am from virtual mode. Millard, I am from virtual mode.
I can see that. Don't worry.
Millard, this is a application for under section 528 of a BNSS to pass the proceedings of the Honorable Family Court. The case number CRLMP 293 to 2023 is under section 128 for enforcement of the order of the maintenance. Millard, the petitioner is 62 years old and the wife is staying in the house of the petitioner also, and he is doing several cases after cases to the against the petitioner.
Issue notice. Yes.
Orders. 64.
All three are there. In challenging the order of proceedings, I had I wanted to raise all these points at the time of framing of charge. The only issue is that since the petitioner was sworn and absconded and charge sheet was submitted, non-bailable warrant has been issued. Your Lordship protected me and then granted the stay of NBW till my date of surrender. My only grievance that since co-accused persons have been granted bail, your Lordship indicate that to dispose of courts below, shall dispose of my application on the same.
Have you moved application for modification?
Yes,
Modification of this order?
Your Lordship's order dated
11/3/2025.
11/3/2025 at paragraph 5, your Lordship given me liberty. That last line.
Liberty is granted to the petitioner to avail remedy under law and after surrendering the.
Can I have given some other cases your Lordship passing that order? I have extracted that for certain. Can that be paragraph 3 of my petition? I have
application, your application.
This application, paragraph 3.
Application number, okay.
797.
Paragraph 3.
Yes. The italic portion, I have extracted from other orders passed in other cases. Will surrender move for bail? Our application may be considered.
That is always there.
No, that is not there in my order.
For the reasons stated in the application, the same is allowed. The order dated 11/3/2025. Para 5 of the order dated 11/3/2025 is modified. Shall be replaced by the following paragraph. Replaced by the following paragraph. The paragraph लिखिला पर एठी application रे एटा italic ଲେଖାଇଛି. subject to the petitioner surrendering before the court below and moves for grant of bail on all the grounds, including the ground of propriety. If such bail application is moved by the petitioner, both the courts below shall consider the same on the same day on the basis of the material available on record. That is your order. Okay.
Three applications, 64, 65, 66. Three matters.
Three matters. There is the last paragraph. Replace paragraph also by the following paragraph.
Item 59 meter or in item 59, 58 meter the petitioner was not appeared in every date, my lord. And 59 he was appearing. For which manner that function may be waived out.
Which one? Already done, na?
Yes, my lord. The same order it has taken. All that.
59. And I passed the order, you said yes, now.
Modification of order, my lord. That both he is appearing before the Narcotic Control Bureau and
I know that. Therefore, he has been appearing. I know that. I will not write that he is a defaulter. But in the same day, in both the places, he will appear. That's all.
in both the cases.
In the same day, in any case, he has to come to the court. On the same day, you will go and report to the bureau. What is wrong in it?
That's it submitted and prosecution already
Okay,
received the
let him continue for some time, then you move application, I will modify it. We have to see the conduct. See the conduct. Otherwise, he will not, he will be defaulter there. I know that is the because they are from West Bengal. They will not come, then again warrant 82, 83 proceeding, all these things will follow. You try for some time, you will see.
Next time.
And again you move application, I will modify that.
Yes, lots.
And when you move application, please file the proceeding before the trial court. All the proceeding. I want to see whether you are appearing there.
Copy I will file.
Once you appearing there, then I will.
Yes.
Next item, 67.
What do you want?
On the acquisition.
I'll come. Wait, I'll come. Yes. Yes, madam.
Sir, I want to mention in weekly list, my serial was 117, sir, but it could not be reached. So please give me another date.
You are the petitioner.
Yes. Eight by 17.
117.
Vijayani Vishwas.
Sir,
Vigilance custom.
Who is your lawyer?
Durga Prasad Mallik, he is not here now. Next week, please, sir, give it that.
Is he ready for
Yes, sir, yes.
arguing the matter?
Yes, sir, yes.
Written submission and everything is ready.
Yes, sir, yes.
Where is your written submission? Give a copy to Mr. Das so that he will also prepare and.
So in that day only he can give, sir. Next.
No. Advance copy you give it to Mr. Das so that he can also prepare his.
Please, he told that he will give on that day only.
Sorry.
On that day only he will give.
If we on that day if you will give and he will say that I will read it. So that is the reason I am saying please supply the advance copy of written submission to Mr. Das so that he can also prepare. When I will take up the matter, I can dispose of.
But sir, this is a criminal case now, sir. If we'll give all in previously, so that we cannot
That is the
get
proceeding,
a sir, please, sir.
What
Please,
she
sir.
trying to say is something else. He said that why should I disclose my argument to you?
Yes, sir.
She want to say that why should I disclose my argument to
Yes, sir, yes.
the other side? That's what it is.
No, sir, please,
Madam,
sir.
ଶୁଣନ୍ତୁ।
On that day only we will, sir.
No, ଆପଣ ସେଇ ଜିନିଷ wrong ଶୁଣନ୍ତୁ ଏଇଟା ହଉଛି କ୍ରିମିନାଲ ଏପିଲ
Sure.
ଯାହା ରେକର୍ଡରେ ଆସିଛି ତା ବିଷୟ ତା ଉପରେ ଡିସାଇଡ ହବ ଆପଣ ଯଦି ଆପଣଙ୍କର ଆର୍ଗୁମେଣ୍ଟ ଟା ଦେଇଦେଲେ କଣ ସେ ନୂଆ ଜିନିଷ ଧରି ପଳେଇ ଆସିବେ ରେକର୍ଡ
On that day we will submit, sir. Please, sir, please, kind, sir.
ଠିକ ଅଛି ଆପଣଙ୍କ ଇଚ୍ଛା ତାର କିଛି ଅସୁବିଧା ନାହିଁ ପ୍ରିପେୟାର କରିକି ରଖନ୍ତୁ ରେଡି କରନ୍ତୁ and take it up ଠିକ ଅଛି
Sir, on next week, sir.
ନେକ୍ସଟ ୱିକ୍ ଦେଖିବା ତାକୁ ପ୍ରାୟୋରିଟି କରି ରାଉଣ୍ଡ କରିଦିଅ ଠିକ ଅଛି
One date.
ଆପଣ ଆଡଭୋକେଟ କୁହନ୍ତୁ ରେଡି କି ଆସିବେ
Yes, sir. Yes, on one date, sir, given.
yes ଲେଖି ଦେଇଦେବ
ଆପଣ ତ advocate ନା?
ଓକେ ଥ୍ୟାଙ୍କ ୟୁ ODAPS. No ODAPS even on the second call. In the interest of justice, release the letter after 6 weeks.
Item 8.
May I please, Your Lordship?
The parties are present before this honorable court. Charge sheet has already been submitted. Your Lordship complied the certified copy of the charge sheet.
294506.
290?
294506.
What are the allegations, Rachi?
Page 10.
Page 10, huh?
Yes, ma'am.
Yes. Yes.
Serious allegation.
What is your name? All these things are what is both of them are adults. These are consensual, everything is consensual. And the money has been
Money
paid.
has already
Money has been paid. Where is the petitioner?
Petitioner is there, ma'am. Yes.
Yes. And the opposite party?
My lord.
Okay. Madam, you have settled.
Yes.
You got back your money. Shall I stop? Close it. No problem. Who is your lawyer?
My
Okay,
lord.
Piri.
My lord.
Piri. Identify her.
Yes, ma'am.
Yes, set up. At the instance of opposite party. Number 2, the FIR number so came to the instead against the petitioner. And the allegation against the petitioner is also. Charge sheet filed?
Yes, my lord.
Tell me when the charge sheet was filed.
23 January 2025.
Huh?
23 January 2025.
After investigation, charge sheet has been filed in the present case on 20th January 2025.
20.
For alleged commission of offenses.
294 506.
294 and 506 IPC. Before the charge is framed.
Yes, sir, my lord. December 2020.
25th February. December. 25th December 24, my lord.
25th December
24, my lord.
24. Offenses are
506.
okay. And the when the before the charge is framed and trial could commence, the parties have entered into settlement. On the basis of settlement, the petitioner and opposite party number 2 are present in the court. They are being represented by their respective counsel identified by them. They have also filed separate copies of the record to establish the identity. The parties have filed. The opposite party number 2, the informant, has filed an affidavit for this court inter alia stating as under. Para 2, para 1 to 5. 1 to 5. 1 to 7. 1 to 7. the opposite party number 2 is present in the court on query from the court submits that she has already settled the dispute with the petitioner and she has got back her money and she has no grievance left against the petitioner. He doesn't want to prosecute the petitioner anymore. Therefore, he joins with the petitioner, praying for quashing of the entire criminal prosecution initiated by her against the petitioner. At least for the state, it submits that since the dispute is inter se party, they have settled the dispute. The disputed amount has already been paid back by the petitioner to the informant. Both the parties have filed affidavit into this court. Therefore, there is no legal impediment in causing the trial. Regarding that to the aforementioned, not guaranteeing
Item 9.
Item 9 है फिर तो adjournment.
Adjourn.
Item 18.
Item 18, politically out of station, therefore, I prefer an adjournment.
Sorry?
Conducting counsel is out of station.
Who is conducting?
Mr. Swaraj Patel.
On behalf of Mr. Swaraj Patel, counsel for the petitioner, and adjournment is sought. This matter after 6 weeks.
Okay.
19.
19, they also wanted to file their order.
Yes.
That's what I wanted to know. If the order is available, there is only a rejected direction. This is not the first or second. I say for passing of that directed to matter, they are directed to surrender matter. First or second.
What do you want?
Right, to surrender first or second.
You have criminal antecedent, therefore the anticipated bail is rejected.
My lord. Only my lord surrender, my lord.
You surrender.
Directed matter.
You want to surrender, let him surrender. Petitioner has, although in this petition, petitioner is seeking quashing up for the Sahid Nagar PS case number 242 of 2024. 2024. However, at the outset, legal counsel for the petitioner submits that he would not address the petition, rather prepared to appear of the charter before the court and resort to the remedy available to him under law. The legal counsel for the monthly legal counsel for the state brought me the notice, brought notice of this court, the order dated 20th, 20 passed in ABPL number 8537 of 2024, whereby the anticipatory bail application of the petitioner has been rejected on the ground that petitioner has criminal antecedent. Regarding head to the same, I am not inclined to although entertain this petition. However, liberty is granted to petitioner to appear surrender before the court and resort to the remedy available to monthly. Yes.
Parity.
Yes.
Parity.
20.
Co-accused person religion parity.
Co-accused bail application of co-accused also rejected here.
No, my lord.
Because of antecedents.
No, my lord.
Just see there are two accused.
Two accused. Another accused, my lord, is granted.
It is open for the petitioner to move bail application, urging all the grounds available to him, including the ground of parity, if available. Yes.
Item 20.
Yes. Yes. What is this? Yes. What is he seeking? Trimming of charges.
State file कुछ भी
304. Okay. non-APS for the petitioner. Even
In the instance of state, they filed the challenge.
state has come.
Yes. It will pass over.
What password?
Monday, Tuesday, then.
Against discharge, you are coming.
Perhaps I have not idea about that. What is the challenge here in this application?
Against discharge under 304. Non-appeals for the petitioner and the decision after 3 weeks. Yes, sir.
May I read the letter, Miller? In this criminal appeal, Miller, I am inside the custody, Miller, more than 4 years. Out of substantive sentence, Miller, 10 years, Miller. And Miller, on the accusation of Miller, 37 kg of ganja has been transported by the two appellants, Miller. And in this connection, since I been in the custody more than 4 years, I moved an interlocutory application by the IA number 821 of 2025 on last occasion, myself directed to State Council, Miller, take notice on the ground that
Yes.
for
My
praying
lordship,
for 2 months.
interim bill cannot be granted because my lordship, I have one judgment also, section 32A also bar my lordship. Kindly have glance to section 32A of the NDPS Act.
Yes.
May I read your lordship?
32
A.
A. Yes.
No suspension, remission, or communications is any sentence awarded under yes communications awarded under this act. Now, standing anything contained in CRP Code of Civil Procedure 1973 or any other law for the time being in force, but subject to the provisions of Section 33, no sentence awarded under this act shall be suspended or remitted or commuted. My lordship.
It is neither suspension.
But here is the suspension of
remission nor commutation.
My lordship, they have filed for the suspension.
Interim bails are not commuted.
My lordship, kindly have a glance one judgment. I am showing my lordship. That also cannot be granted, my lordship. This is Honorable Supreme Court judgment, my lordship.
32 capital A will not be applicable.
37 also born, my lordship, because it's a commercial quantity.
What is the ground for interim?
Ground, Miller, illness
Only
of family members and so also, Miller, considering the Article 21. Considering the
So then you are asking for regular bail.
Yes.
Article 21, I have already served 4 years. These are the grounds for the purpose of regular bail.
That is also.
Interim bail means some medical urgency, those things.
Not a single ground they have not a single ground they have made in the IA for the interim bill, my lordship. Not a single ground they have made in the IA for the
interim bill. I know that.
The ground should be written, my lordship. In para 9, kindly have a glance, my lordship.
Yes, which para?
While considering the rival submission, we must the outset of the advert to the manner in which the learned single judge of the High Court has dealt with the application for suspension of sentence under Section 389(1) CRPC. The offence of which the respondent has been convicted by the special judge arise out of the provision of Section 23C, 25A of NDPS Act. The finding of the learned single judge, which has been arrived at after a trial on the basis of the evidence which has been adduced, indicate that the respondent, who was a proprietor of a courier agency, was
I know 389(1) is not applicable. That is the reason I say move interim bail application. He is arguing main application. 389(1) is not available to you.
And para 10 it is clearly said that the High Court has...
I am not exercising a advisory jurisdiction. Yes. I don't know how to, I will not advise you how to draft a interim bail application, and that's your problem.
Considering
you in the application, you are basically asking for regular bail.
Yes.
I am also
These are the grounds for regular
paragraph
bail.
3, Miller, illness of family members, particularly wife.
Where have you said that?
Paragraph, Miller.
Where have you filed any application? Document?
No, my lordship. No document.
Where have you said? Which paragraph?
Miller, paragraph 2, Miller. So the wife of the applicant is suffering from serious old age disease, Miller. In fact, Miller,
some document you file, I will get it verified, then I will
for a moment, here. In fact, this matter was listed for here. and then it has been listed, but could not.
And you said that I am already there for 4 years.
4 years?
I asked you to move an interim bail, I'll see.
Yes,
And you have narrated all the regular bail, 389, one is barred. What to do?
ତା ଦେହରେ ମିଳେ ଆଉ ଆଣିବି କଣ ଗ୍ରାଉଣ୍ଡ ମିଲର ତା ଦେହରେ ସେ ତ ଫ୍ୟାମିଲି ମେମ୍ବର ଇନଲେସ୍ ମୁଁ
I will not advise you what to do, you must know that.
ଆଉ ସେଥିରେ ଗୋଟେ 2 ମାସ 4 ବର୍ଷ
Now there is an opposition with armed with a judgment.
And another also judgment I have, my lordship.
Instead of wasting time, let us hear the appeal.
Yes,
Tell
sir.
me when can you argue?
Tomorrow also, tomorrow at 10.
Tomorrow, Sunday or
already I filed my written note. Whenever my lord pick the date, I'm
least it on 5th. 5th. If I get time, I'll do it. 5th Saturday.
ସେଇ କଥା ଯଦି ବି ହେଇଥାନ୍ତା ସେଦିନ ମୁଁ ଖାଲି ମୋର written note
But for hearing appeal, it takes time from other side also to get ready. There is a NDPS case.
ମୁଁ ଦେଲିଣି 4 ମାସ ହେଲା written note.
They should also be ready now. Every day they are handling miscellaneous matters. They should also get ready then.
That's why Miller, no otherwise interim bail file korthanti.
Mrs. Maharana, please Saturday get ready.
On the consideration of the state, Miller interim file. Mu interim
okay, Saturday 5th she will get ready.
Yes, my lord.
The document paperwork you have?
Yes, Miller. Everything. I also
you
file
give it to her. She may not be having.
Do you have
Yes, my lordship. I will also file a written notice of submission.
Do you have the entire paperwork with you?
Yes, my lordship.
Then you get ready.
Yes.
On 5th, yes. ମୁଁ interim bail କାଇଁ ମୁଁ ତ ପୁରା final
here.
My lordship. The defendant is petitioner before my lord. Assailing the order dated 19/7/18 passed by the Lalent Civil Judge Unit Division Sonpur in CS number 211 of 17, wherein the Lalent Civil Judge has allowed the application filed under Order 9 Rule 7, thereby setting aside the expiry decree, but did not accept my written statement. That is under input before my lord.
Yes, which part?
My lord,
28, page 28.
Page 28.
Let us see.
My Order 9 Rule 7 application setting aside has been set aside, but did not accept my written statement. But fact remains, the suit was posted to 22/11/17.
At what stage the suit was dismissed in the court?
Suit was not dismissed, my lord. I am the dependent. Suit was posted to 22nd November 2017 for filing of written statement. I was supposed to file written statement. On that day, I opened adjournment application for filing of written statement. That petition rejected on the ground that since 90 days period has already over, the application rejected. Then matter was posted to any next day. I could not file any steps. Matter was posted to 4/1/18. On 4/1/18, I made an application under Order 9 Rule 7 for setting ex parte order as well as to accept my written statement. Court below set aside the ex parte order, but did not
pass any order in that application.
Yes, order has been passed, my lord.
Where is that?
Partly it has been allowed and partly rejected. Lordship,
you had moved 9/7.
9/7 allowed.
That is allowed. And what about the other application?
One application, 9/7, I filed application under Order 9 Rule 7 along with written statement. 9/7 application.
Have you moved an application for taking on record written statement explaining delay?
Well, if 9/7 will be allowed,
then
there was no fighting.
No, 9/7 is allowed doesn't mean that it will automatically written statement will go on record. Unless you explain the delay beyond 90 days. Where is that explanation?
Explanation, my lord. Let's see, kindly have a glance.
You should have moved a separate application.
Yes, that is for acceptance of written statement. Lordship is correct.
Why have you not done it?
But I have mentioned, my lord, that page 15.
15, 1/5.
That non-filing of written statement in due time was not intentional nor willful.
Now the suit is restored. Let him move application, fresh application. Let the trial court decide it. Move fresh application.
Trial court has already rejected it, my lord.
It's not rejected.
Yes, my lord. Rejected it, my lord.
Rejected.
Where is that?
Lordship, kindly have a glance to improve order, my lord.
Your lordship, may kindly come to page.
Let me complete.
Yes, you complete.
Lordship,
Page 31, my lord.
Page 31.
Yes.
Being guided by the case law as discussed above, this court is of the view that though the petitioner has sought for setting aside of the ex parte order, so also to accept the written statement filed at a belated stage, it will be appropriate and just to allow the petition only partly. Therefore, this court is inclined to set aside the ex parte order passed against the defendant number 1
on date 18/12/17. However, the prayer for acceptance of written statement cannot be allowed automatically in the same petition, which has been filed under Order 9 Rules.
That's right. That's what it says. File a separate application.
I will move application to
Yes,
for acceptance.
that's the reasoning.
Yes.
Right reasoning.
Because
In
my-
9/7 application, how can you ask for?
Yes, Lordship is correct. Along with 9/7, an application is to be
You
made for
should have
acceptance.
filed a
Yes, ma'am.
separate. That is why the trial court has rightly rejected.
Lordship, I will.
One respectful submission, my lord.
How can you take away the right to
Yes.
move an application? Let him move application.
No, no,
Let
he will
the trial court
move,
deal
my
with it. Let the trial court deal with it. Right on. Petitioner is agreed by the order dated order dated 19/7/2000.
Lordship, may I pray one line, my lord?
Pass by.
Lordship, mentioning that filing of 90 days, written statement 90 days, it not a state iron form. Lordship, keeping the view of the Lord laid down by this court.
I will not say anything. I'll set aside. I allow you to move application.
My lord.
Let the trial court take the call.
My lord.
Petitioner is agreed by the order dated 19/7/2018, passed by learned civil judge senior division Sonipur in civil suit number 211 of 2017, whereby the application of the petitioner, public defendant number 1, under order 9 rule 7 CPC has been rejected. Has been rejected.
Allowed.
Although allowed.
Allowed, but
although
written
allowed.
not accepted.
But the conjoint prayer for allowing him to file the written statement has been turned down. The petitioner, it appears that the petitioner has been proceeded ex parte. A petitioner was granted. Where is the proceeding sheet? Where is that proceeding sheet?
Proceeding, my lord.
When was the written statement was supposed to be filed?
Supposed to file on 22/11/17.
The petitioner appears to have failed to file the written statement within the stipulated time frame. Therefore, on date
4/1/18.
24/1/18, his right to file written statement was forfeited, and the matter was posted.
My lord, forfeited was on 18/12.
18/12 forfeited, and the matter was
6/2
listed on
4/1/18.
4/1/18.
On which date I made application?
On that day, the petitioner has been proceeded as part of. Therefore, the petitioner moved the application under Order 9, Rule 7. In the same application, the petitioner has also made a additional prayer for the purpose of taking the WSN record. While dealing with the said application, the trial court has passed the impugn order, inter alia recording as under. Last paragraph, paragraph 31. Page 31. Page 31. I've heard the submission on both sides. This one you read, which one? No, paragraph 31. No? Page 31. Last paragraph. Being guided. The petitioner is aggrieved by the fact that although the ex parte order passed against the defendant number 1 has been set aside, but his right to file, but his prayer to take on record the written statement has been turned down. The trial court has observed, while rejecting the prayer of the petitioner, that in an application under Order 9 Rule 7, the prayer, additional prayer made by the petitioner cannot be allowed. In that view of the matter, cannot be allowed. I have heard both the parties at length. I am for the considered view that since the suit is restored, since the ex parte order has been recalled, and the defendant number is allowed to support the suit, he has right to move application, separate application, praying for taking on record the written statement, written statement. The liberty is granted to the petitioner to move separate application in that regard. If such application is made, the same shall be considered in accordance with law, in accordance with law by the trial court, and then proceed with the trial of the suit.
My lord, I respectfully pray suit is the year 2017. Your lordship may target.
In view of the led causes for the respondent submits that since the suit was filed by him in the year 2017, and is elongating for such a long time, a time frame shall be fixed for the purpose of disposal of the suit. Disposal. I mean, our written statement is not filed.
Pleadings not completed, but how can you pleadings pleadings is to be completed, issue is to be framed.
In view of the fact that
Pleadings is to be completed, then issue is to be framed.
Suit is filed in the year 2017. The trial court should do well to see that the trial of the suit is concluded as expeditiously as possible. Yes.
And my lord, unnecessary adjournment may not be granted. Your lordship we undertake both the parties.
As a executor to this, the parties, the trial courts are not entertain unnecessary adjournment. On the behalf of either the plaintiff or the defendant.
69.
Yes. Adjournment.
I am for the petitioner, your lordship. He is informed.
What is this matter?
Right, here the order 6 rule 17 amendment of plaint was rejected. The ground of rejection was that it will change the nature and character of the suit, but rather that application for amendment was a formal one, and due to incorporate the subsequent changes, that amendment was preferred, my lord. That is the subject matter of challenge.
Show me the.
Yes, your lordship. The schedule of proposed amendment is page 60, your lordship.
60.
60.
Yes, point.
Kindly, because I am not the contracting counsel, also Mr. Sambit Mahanti is.
There is any the interim order is there to this state. On behalf of opposite party number 2, an adjournment is prayed. Lease the matter. Interim order is operating against you. Unnecessary you should have. Yes,
that will be continued.
Interim order to continue. Yes.
Okay. Much obliged.
70.
Lordship, petition is the plaintiff matter. Suit for partition. Against the rejection of amendment of the plan, this CMP is filed. Rejected on the ground, matter page 43, annexure 5, page 49, my lord. On the ground that it will take the admission, withdraw the admission of the plaintiff matter. The present case, the plaintiff patient described defendant number 3, Kunti Maharana, as his mother, and by way of proposed amendment, the plaintiff wants to withdraw that admission by stating that defendant number 3, Kunti, as the kept of his father, Kunti Maharana. The petitioner completely failed to show that such admission is an outcome of wrong and erroneous in a mistake. In this case, my lord, annexure 1, my lord, plaintiff itself.
Yes.
In this case, in cause
you are the plaintiff. You are the plaintiff.
Plaintiff, my lord.
Yes.
In the cause title itself, the plaintiff is described age of 60 years and defendant number 3, age 69 years, my lord.
Here.
And in page 15, my lord.
15, yes.
51, 5, my lord. In genealogy,
yes,
the plaintiff is described as the son of defendant number 3, my lord.
Kalandi.
Son of
Kalandi.
My lord, Kunti. Dispute is Kunti.
Yes. Yes.
Subsequently, my lord, in page 17, para 4, Kalandi is dead.
Defendant number 3 is Kalindi.
Kunti, my lord.
Okay, wife of Kalindi, mother of your mother. Your mother, yes.
Dispute is the Kunti is not my mother. And page 17, my lord, para 4 re Kalandi is dead. Plaintiff and defendant number 1, 3 are legal heirs. This is the averment in the plan. By virtue of amendment, page 34, my lord.
34.
34. 32 the amendment petition, 34 is the relevant portion of the amendment, my lord.
You say that Kunti is not the wife of
Kunti is not the wife of
Kalindi. That's your case.
my lord.
Okay.
Defendant number 3 Kunti is the legal married wife of Prabhakar and Viramitrapur under Jajpur Sadar PS district, Jajpur. She Yes, man.
Yes.
Not
the super partition.
That has been rejected.
Rejected.
Yes.
The super partition. The lordship can see the super partition 21 dependent at the same time. He filed the suit, disclosing that he is my son. Alonli is his father. And
But Kunti is not the mother. That's what.
let me, lordship can see the constant. Page 14.
14.
Gandharva, son of Kalandi. Valyas Aleko, Kunti, wife of Kalandi and son of. Am I correct?
Name.
Valyas Aleko, both are son of Kalandi.
Kalindi, yes.
Kunti, wife of Kalandi. Kunti is the wife.
Now it's Sutara.
What-
Prabhakar Sutara. Now he
He
wants
said that I am the cape of Kalandi. One bully is the wife of Kalandi. And my husband is someone. Any city. Genuine. Page 15. Kalandi.
Wife.
Kunti.
wife.
Kunti. And accordingly, your lordship went on to page 16. The plain story is not that out of here. He claimed
Page
16, schedule A property.
Yes.
A is recorded in MS number in son of Kalandi Maharana, son of Bhuti Maharana, Jaladhara alias Babaji Maharana, Benudhara Maharana, Chintamani Maharana, so on and so. He has disclosed the detailed genealogies in respect of schedule A property. And so far Kalandi is concerned, his date, and you see the paragraph 4 of the claim, that is page 17.
Kalindi is dead.
Kalandi is dead. Plaintiff and the defendant number 1, 2, 3 are the legal heirs. Dhoni and his wife Surugi died behind this one and Jaladhar Benudhar. This is an admission that I am the wife of.
No, this is not an admission. See, Kalindi is dead, no problem. The
Kalindi is
plaintiff
dead.
and defendant number 1 and 3 are the legal heirs. There is no issue.
No issue.
Because he's not saying that I am not son of the Kalindi. But what he says is, Kunti is not the wife of Kalindi.
Once he has admitted that he is my son. By way of amendment, he said that I am a kept of someone else, but he is not my son.
No, he doesn't say he's not my son. He only says that
No, kindly see.
Kunti is not the wife of
No.
Kalindi. Rather, he is the wife of Prabhakar Sultan.
I have filed away written set. Mother has filed. I am from the mother. Kunti.
UFO.
Yes. Can you see the proposed amendment?
You are
It has
to see.
omitted first page, which is important.
UFO 1 to 3.
I am for one.
Yes.
Yes, 33 can you see.
33.
After name and age, this wife be deleted in place that kept to be inserted, substituted.
Where is that? 30?
33.
33. 1 minute. What is this?
Well, this is the crux. I am the kept and he is my son. His sonship as he has not disputed. He has not denied that he is not the son of Kalam. He said that I am the kept of Kalam. Second, genealogy Kunti D3 be deleted. Then in line number 2, paragraph 4 to 1 to 3 be deleted. And 1 to 2 has been substituted. And the entire plaint has been amended. Your Lordship can see page 34 and 35. Paragraph 4A, 4B, 4C. Next, can you see 4B?
The entire narration is changed. Now,
the fundamental and the constitution of the plaintiff has been changed. And moreover, the learned trial court has committed mistake. Nothing will be mistake. Kindly see the findings, page 47. Before delving the issue into issue.
30?
47.
47.
Yes.
Yes.
Before delving into the issue, it is opposite to go to the proposed schedule of amendment. Through the proposed amendment, plaintiff wants to incorporate amendment number 3 is not the wife, but the kept of colony. One Bully Maran, daughter of Hikari Maran of village Barada, is a legally wedded of the So through such amendment, plaintiff wants to withdraw his admission that defendant number 3, Kunti Marana is the wife of Kalam, he is not the son of Kunti. During course of hearing so and so, plaintiff put for the argument in admission as you withdraw. Next for country. Then your Lordship can see page paragraph 6. Next page 48. These are the learned trial court has taken note of that Usha Balasaheb Ambedkar's case where the written statement can be not taken as a claim. But second paragraph, the leading judgment of the Honorable Supreme Court that your Lordship has knows that Ram Niranjan Kajria's case where
Yes, my lord.
admission is deprecated.
Yes, sir.
And what is the stage of suit, sir?
What is wrong in this?
Sir, suit has DW1 has been examined. He has cross-examined in part on 13/2/2023. Then filed writ application here, submitting that suit has not yet been commenced. Accordingly, this on report.
No, there was an order. There was an order earlier passed. That is on 20th February.
Yes.
What is the stage of the trial?
The stage of the trial.
So-
The entire order. My lord, can we see the evidence of DW1?
DW1.
DW1.
And let us see the last order. Take the last order.
Awaiting intimacy.
Written statements have come now.
No.
Written statement depending on 9A to
9A, 9C written statement has come.
Can you see the order dated 23/11/23?
23/11/23. 23/11. Yes.
23. No intimation. No.
Yes, intimation. And so far the cross-examination is concerned, my lord, your Lordship can see order dated 14/2/23.
Yes.
14/2/23.
Yes.
Advocate for both parties present. Advocate for plaintiff file affidavit statement of one place, namely Kunni Maharan as DW1. She further examined partly cross-examined by your plaintiff, exhibit 8, which is your advocate for plaintiff praise for them. There is a rider in amending provision of the CPC. Proviso under order 6/17. If there is a commencement of the trial has already been commenced, and there is no due diligence at all.
In this case,
you have, sir,
sorry.
Yes.
Sorry.
You have participated in the cross-examination, cross-examining part. You sought for an adjournment for deferral. Subsequently, you completed the cross-examination. Now file the writ application here. And your Lordship in case of that is latest judgment of 2022, LIC versus Sanjeev Miller's case in paragraph 71. The Honorable Supreme Court has made a guideline. You may submit, my lord. Can I produce the judgment? Honorable Supreme Court in that
Yes. Yes, I understood. Yes, sir.
My lord,
Yes. What do you want?
in this case, my lord, the DW1 examined by
I would have allowed your petition if the suit would have been something else. It is a suit for partition.
My lord.
It is a suit for partition.
My lord.
And you can't change the entire character of the suit. After having pleaded very specifically and at the advanced stage, you can't completely change it. Your object is only to outstate 1 and 2 on the property.
My lord, suit, I have not examined, plaintiff has not examined any witness. On the petition order 8 rule 15, defendant number 3 examined as DW1 on outcome basis.
In the first instance, see, in the first instance, why have you filed the suit describing Kunti as the wife of your father?
My lord,
You don't know who is your mother, you don't know who is your father.
My lord,
And at the advanced stage in a partition suit, you come and after several years, you say that no, he is not my father, he is. See, bona fideness has to be seen from the totality of the circumstances.
My lord, suit in the year 2020.
Don't forget that it is a suit for partition.
My lord, suit for partition. My lord,
You should know who is your father, who should know you are claiming the property, ancestral property. And you have narrated, not in one place, in many places you have narrated the plaintiff. And turn around after the witnesses are examined and you say that she is not my mother.
My lord, cause title, the age of the plaintiff is 60, whereas the defendant number 3, who has been described as a mother, his age is 69. My lord, the difference is 9 years.
Describe my age.
In a different,
describe my age.
What is your age, by the way?
My age is 60 as per the plaintiff, my lord.
No, what is your age originally?
Originally, my lord.
That may be a typo, whatever.
No,
what is your age? You tell me first. Show me the affidavit.
One document has been exhibited,
my lord.
legal certificate, where my age was 77 years. By
My
the-
affidavit is
And what is the crux, my lord? He has obtained a false legal certificate, and which has been cancelled by the appellate authority. Then and there he has filed a suit disclosing.
This
for exhibit, my lord, A is concerned. My lord, for a moment, can you see exhibit A?
I can't see any bona fide attempt on your part.
Because due to ignorance of the party and illiteracy.
How can you claim the property of your father? You are ignorant about who is your mother, who is your father, and you are asking for amendment. I tell you, you have a good case. Had it been another suit, some declaratory suit or something, I would have entertained. It is a suit for partition.
Because
And the best thing would have been you should not have traced it. There is no res judicata. You should have filed a separate suit. So why have you asked for amendment?
My lord, page 31, my lord, Annex 2. The Kunti Maharana.
Leave it there.
They have stated
Leave it
that
there. You will get your share. Don't worry. You will get your share. Don't worry about it. Let your brothers also get some share. You want to oustate them from the property. That's the only object.
I am not asking the mother.
You are attacking the mother so that the mother goes, then along with the mother, 1, 2 also goes. That is your object.
No, my lord. My object is
I can see that.
My defendant number 3 is not the mother of plaintiff.
You are aiming at defendant number 1 and 2.
Defendant, no, my lord.
Yes.
In my amendment, I have
Your
stated-
entire amendment is attempt to oustate defendant number 1 and 2.
Defendant number 3, my
No,
lord.
in the process, 1, 2 also goes.
No, my lord. I have stated that the
That's the idea. That's the idea.
My lord, I have stated I am the defendant number plaintiff and defendant number 1 and 2 are the son of Kalindi.
It's all right. If the Sorandi, they are entitled. Okay, your mother, Kalindi will get a small share out of the whole property. Let her
Defendant
take.
number 3, defendant number
Even if she is concubine according to you, even if she can get something, let her get. How does it make difference to you? You will get your share.
So,
No, I'll not. Yes.
Admission can be taken away. So,
Don't. This is partition suit, sir. You will get your share. What is this? Only for the purpose of a small share, you are bringing. You are doubting the character of your father. Everything you are doing.
Plaintiff cause title averment itself shows how the ignorant of the plaintiff is, how the plaintiff is ignorant.
Yes. So, hard copy achi? Hard copy? Huh? Give the judgment, you send it. I'll write. Yes. Yes. Hmm? Yes.
71.
21, my lord. The contempt number 3 has filed a compliance affidavit yesterday, my lord. There are three contemners. Three contemners.
Awaiting the instruction from the higher authority. It is the order of 2023 passed by your lordship. And
Where is that?
no stay
Yes,
and
compliance affidavit
consequence
has been filed yesterday by the contempt number 3, awaiting the approval order from the higher authority.
Who is that higher authority?
Higher-
The High Court says do it. Who is that higher authority?
Two.
My lord, in order to comply
Nothing doing. You call that higher authority also.
we have sent
Majesty of the court has to be maintained.
Yes.
Who is that higher authority to scrutinize our order?
We have
Show me that
complied to
affidavit.
the extent.
Show me that affidavit. I'll ask
Yes,
him
sir.
to pay fee this person.
He has written
Give that.
2-3 letters to the higher authority too. Additional director.
After having received the, we have taken
No,
prompt
Mr.
action.
Not tolerate this kind of affidavit.
We have taken prompt
If the
action.
High Court passes an
After-
order, who is the contemner to say that I am waiting for the higher
No,
authority?
contempt, there are three contemners, your lordship. The concerned authority, has to give the approval.
After High Court order, the concerned authority will give approval. Therefore, we will wait for you.
We have sent letter to
Who is
the
that?
contemner.
Who is the concerned?
The additional DG.
Let him come and appear before the court. Let the additional AG come and.
Sometimes it is necessary in
nothing.
to comply.
No,
with
no,
the
no.
order.
The majesty of the court's order. Actually, no, nothing to do.
Contempt number 3 is the concerned authority.
2 is the higher authority.
Higher authority, 1 is the appellate authority.
One second kitchen. Appellate it. Higher authority. He has written 2-3 letters to the higher authority OP2. Additional DG.
After receive the order from this honorable court, we have taken
What is
step,
this?
my lord.
What you have written, therefore, this office is awaiting for the instruction from the higher quarters
Yes,
for
sir.
compliance upon the order dated of the High Court. What is this?
Your lordship,
Who is this
paragraph
man
4,
who is
your
giving
lordship.
affidavit?
OP2, my lord. OP3 has given this affidavit.
This is the OP3 has filed this affidavit, my lord.
You just tell me one thing. If the High Court has passed the order,
Yes,
do
ma'am.
you need approval from the senior officer to comply it?
That is the official administration process there.
Nothing doing. No, nothing. If the High Court passes the order, you have to comply. As simple as that. Or otherwise, go and challenge. If you are,
We need some time. I am praying for some
where have
time.
you said need time? You say that I am waiting for the
Yes,
instruction.
OP3, my lord.
We need some time from the OP number 2.
This is the second.
He has to give some instruction.
Categorical stated. If there is no stay, it will deem to be contempt of this court.
That is some time is necessary, my lord.
The lordship's order is there.
You can't undermine the court's order like this. Which order was not complied? This order is?
29/9/2023.
WPC number.
That is the order passed in the REIT application.
No, REIT appeal, REIT, my lord.
You have not challenged this order? Not challenge this order?
No, it was challenged.
Dismissed.
Or appeal is also
Yes,
dismissed.
your lordship's order has
The
been
petitioner has filed the
upheld.
present contempt petition seeking compliance of the judgment of this court dated what is that? Dated 29/9/2023, pass in WPC number 36822 of 2022. The respondent state has assailed the state judgment for the this court before the division bench by filing writ appeal number.
That is
Filing writ appeal number 122.
Retailer 1228/2024.
Already been dismissed. Despite dismissal of the writ appeal, the of judgment of the single judge of this court dated 29/9/2022 remain remain uncompliant. Therefore, on 7/3/2025, this court passed the following on. In compliance to the aforementioned order dated 7/3/2025, the alleged contemners have filed an affidavit.
Contempt number 3, your lordship mentioned.
And contempt number 3 has filed an affidavit inter alia stating as under para 4. The reading of the contents of affidavit reveals that the contempt 3 is awaiting the instruction from the higher officers for complying with the order of this court.
From the contempt number 2.
The government
contempt number 2.
Contempt awaiting the instruction from
Contempt number
2 to comply the order dated 29/9/2023. The government made in the affidavit is we multiplied the allegation of contempt made by the petitioner. The majesty of the court of High Court needs to be respected by the contender instead of the answering answering contempt number 3 has averred that he is waiting for the instruction from the senior quarter to comply with the order. This court is taking a serious view to the state government made by the contempt 3. Therefore, the contempt number 2, na?
Two.
Yes,
Yes.
Contempt
I have
number 2.
I have also written his name, but your lordship may issue
Contempt 2
by designation.
Contempt 2 is directed to be present physically before this court to explain as to why the judgment of this court has not yet been complied. Release the matter on 25th. Let him come on 25th.
Hon'Ble.
How can you do like this?
Yes.
If an order is passed, you go and you file, you challenge it, that appeal is dismissed. Now you say that I'm waiting for someone. Let him come.
72.
Yes.
Watching of the criminal proceeding in the Hon'Ble case. The case is like this. But the petitioner will be maternal uncle and the opposite party number 2, that is the complainant, is one of the victims. Well, in the year 2006, the sister of the petitioner, that is the mother of the opposite party number 2, filed a suit. That is
Who is, by the way, appearing for opposite party note? Service is complete.
I am appearing.
You are appearing, Mr. Mishra?
Yes.
Yes.
filed the suit in the year 2006, that's CS number 825 of 2006. There, the main dispute was that the petitioner is not the son of Loknath Samantare and he is the son of Loknath. Well, here, I'll take a pause and I will submit that. Well, in fact, 4 brothers. 4 brothers. No brother has any male issue. Only Loknath has a son and a daughter. His son is the present petitioner, and daughter is Pramila, who is was plaintiff in that suit in 2006. In the suit, there was a compromise. There they admitted that I am the son of Loknath, not Raghunath. And in the suit, out of 7 acres of land, 3 acres of odd was given to her. She got it recorded in her name.
Suit filed by whom?
to find my sister, that is the mother of the opposite party, number 2. Now sister is no more. She has been. And that the suit was compromised, decree was passed, and that was also carried out. She got the land that fell in her share, recorded in her name, and she also sold the same. I have given all the documents.
Yes.
So after 3 years, she filed another petition, that is CMA under 151 the CPC, saying that the compromise has been done in a fraud manner. I was not conscious of the compromise. After selling all the land, they filed a petition. I challenging that. I approached this honorable court in the civil division. Initially, I have stated that it was stayed. That proceeding was stayed. By now, that proceeding has been disposed of. It has been demanded to the trial court, and it is pending there. Whether I am the son of the
Raghunath or Loknath?
That is the issue. They settle the issue.
What is your case? Raghunath or Loknath?
Loknath.
Loknath.
I am the son of Loknath.
Where is the written statement you have filed in the suit?
Written statement.
Because in the suit you have been implicated as a defendant number 1, stating that you are the son of late Raghunath Samantrai.
Yes.
Where is the written statement? What
that
you?
was compromised.
Have you filed written statement saying that I am not son of Raghunath?
Yes, that issue was there. Thereafter it was compromised.
That compromise is fraudulent compromise. That is the case.
No, they say that the compromise is fraudulent. But prior to that, the lordship, in the compromise, she got 3 acres of odd land. She got it recorded in her name. Thereafter, she sold the land to others. That documents I have given you lordship plans.
Then?
So now, after 2 years, she filed that petition on the section.
She means mother of the opposite.
Mother filed. The mother is dead. By side of the mother is dead, and that petition is pending. Initially, it was before challenged before the honorable court, and this honorable court said that it will be decided by the Lorna trial court immediately. That is pending.
But what you say is the settlement has been acted upon by her.
Yes.
Sold the property. Thereafter she came.
Has already been acted on. So that is the question of fraud is not that. Since they have filed the case.
What is the criminal case now?
The criminal case, thereafter, my lord, after some days, we filed another proceeding under section 144 CRPC have given that order, that case, my lord. That was also said that I am making construction over the land which was fell in my share. So that was not entertained on the ground that it is civil, purely it is a civil dispute and civil proceeding is pending. That is annexure 4.
Yes.
Another proceeding was also filed criminal case that was also dismissed on the ground that it is a civil dispute. So criminal now my lord, he has filed the complaint case after the one of the son has filed the complaint. Of the 4th son of that my sister, one of the son has filed.
What are the allegations now?
The allegation the lordship will get at page, the same civil dispute they have raised. Page 56 or lordship have given.
56.
Yes.
Yes.
That is the part of annexure 6.
Yes.
That the accused Ullas Chandra Samudra, that is the present petitioner, he is the natural born son of Raghunath Samudra. Raghunath Samudra died leaving behind his son Ullas Samudra and Dr. Jharana Samudra. Ullas Samudra, who has been alleged adopted to local Samudra, died leaving behind him only Dr. Pramila Paikre. It may be stated here that Raghunath Samudra was given to village Aiginia. The name of his father-in-law was Doitari Sundara. His father-in-law died without any male issue. So Ullas Samudra succeeded in the properties of Aiginia. This Ullas Samudra is neither the natural born son nor adopted son of Loknath Samudra. This Ullas Samudra is the only son of Raghunath Samudra, neither person, namely Husike Samudra, son of Raghunath Samudra, nor Ullas Samudra, son of Loknath Samudra, in the village Northingpur. That in order to grab the Loknath Samudra, Ullas Samudra used to describe himself as the son of Loknath Samudra, and also.
No, what is the offense, sir?
The offense, they say that in the name of Husike Samudra, I have sold their land. That is their ground. So far the land sold by Rusike Samudra, son of Raghunath Samudra, he is in no way concerned with that land. That is the gifted land of the petitioner. It was gifted by Raghunath. So he sold this land in that land in the ROR also.
Let us see, Hurusike Samantray.
Yes, that is their case. So now the question is, he has no locus to file such application because
Yes, Mr. Mishra.
Just explain
You
something.
see, the allegations are in the name of Hurusike, he has sold, saying that I am the son of Lograth.
Let me.
How are you aggrieved? Who are
Let
you?
me just-
You are the son of the sister, elder sister. You, supposed to be the Mamu.
Let me just clarify many things. Many stories have been told years.
I understood it.
Let him finish.
he is no way concerned with that.
I understood it now. Yes.
Let me just explain. But the stories that have been told is not part of record number one. I'll just explain the background.
No, part of record only. I'm reading from part of record.
No, because he cannot file his possible defense to say the complaint should be quashed. What he has sought for in this criminal case, he has sought for quashing of the complaint. No cognizance order, nothing is challenged before your lordship. Number one. Your lordship will say quashing of the.
Who are you? Why should you?
No, because I have succeeded to Pramila. I am Pramila's daughter. I'll just explain little background. Will your lordship kindly permit me to explain little background? A suit was filed. Suit which my learned senior says, your lordship will see, he was described as son of Raghunath.
Yes.
Your lordship may kindly turn to page
I've seen it.
17. Now your lordship was asking the offences. Let me also say what are the offences for which
he has gone in adoption to Loknath.
No, that I will explain. It is not that. That is the issue. That is why 417, 420, 468, 471 read with section 34 of the IPC. Let me just tell that civil background which my learned senior is giving emphasis of.
Let's come to the complaint. What is
Because the civil background has been told to your lordship, which your lordship has been pleased to point out to me. Let me just explain. Now, the civil matter that was filed was decreed. 151 application was filed because your lordship knows where there is an allegation of fraud.
Yes.
151 application to set aside a compromise decree is maintainable. 151 application was filed. He questioned that filing and order 7 rule 11 application that is not being told to your lordship. He said that 151 petition was challenged before the Honorable Court. No, he filed as order 7 rule 11 application that came to be rejected. A civil division was filed. Now civil division, the Honorable Court has been pleased to dismiss it. Then this kind of order was being downloaded from the website, not the way now it is done. But I have got it from the website, I have a copy. Your lordship may peruse. That means the petition that was filed questioning the maintainability of 151 has been rejected by the court below, affirmed by the Honorable Court in civil division on the ground of fraud. Now, your lordship may kindly say, your lordship was asking what is the fraud. Your lordship may kindly peruse from page 56. If your lordship kindly permits me, I will place till page 58 in extenso because that is necessary. That will demonstrate the offense. Your lordship will see he is not the adopted son of Loknath. That is the issue, and he has projected and done the act.
He has impersonated, saying that I am Hurusike.
Yes, so therefore,
and told it.
Therefore, the criminal.
Are you Hurusike?
My lord.
Are you Hurusike? Have you recorded?
Son of Loknath. Yes, I am not Hurusike. What he has done? He has taken away the property of Loknath. Pramila is daughter of Loknath. I am son of Pramila. So, lordship may kindly consider the connectivity. Now, Pramila is gone. She is no more there. So, I step into the shoes. So, to say that I have no locus standi is not correct. Number one. Number two, let me just place.
Have you filed a suit to declaration?
Suit is one part.
No. Have you filed a suit for declaration that the sale deed executed by Hurusike is nullity, and you are using the criminal procedure for onto it?
No, let me just clarify. Your lordship knows both criminal liability and civil liability can operate in the same field also, where a criminal case is made out. Now, this is a case where I have stepped into the shoes. So far as the 151 petition is concerned, hypothetically, I succeed in the 151 petition. The decree of compromise will go. Consequently, all other...
Will go or has gone?
No, just let me explain, my lord. No, if it goes, then consequently, all these transactions and everything will go. The question of questioning all those in a separate suit doesn't arise.
What is happening there? 151.
My
151
stage, my lord, your lordship may pardon me. I cannot
tell me the stage. I'll say everything till that 151 is decided.
No, man, let me just explain.
I'll say this.
No, let me just explain. Your lordship, may I just place these 3 pages only?
No, simple. See, Mr. Simple.
That.
But
You
what
just
he has
tell
done-
me 151 application which you moved, seeking declaration that the decree of compromise is a nullity under law because it is obtained by fraud.
Madam.
And this complaint is contingent upon that.
Madam, why beg to submit?
Directly contingent.
May I just humbly submit one thing?
Yes.
Then I will have to assist your lordship on the point of law which your lordships have been pleased to hold time and again, that even if there is a civil matter, then the criminal liability can also spring
No,
into
it will
action.
be, it will again depend upon, see, the criminality will again depend upon the decree. If the decree,
No, I'll explain.
decree found to be correct, then everything falls in place.
Hypothetically, I fell in the decree. No, just let. ମୁଁ ତାହେଲେ ଆଉ ଯଦି ପୁରା complete କରି-
No, I
Yes.
got it, yes.
And that I'll explain. May I just place these 3 pages?
No, I understand. You tell me.
Well,
I'll
place
put it next week. You tell me.
Kahin darkar, let me just explain. What he has done. Now, at places, he has described himself as Gusike, son of Raghunath. Then he has disposed of property. Some places he has said, Ullas, son of Loknath. Loknath is my lord, my predecessor. Your lordship kindly, my grandfather.
To whom he has gone as in
Claiming.
head of sir.
Now, this is, may I just place whether this is making out a criminal liability or
What
not?
you are trying to say is the part of the property which should have come to you has been sold by him.
But it's not a question of
by impersonating. So therefore,
yes.
agreed.
So therefore, the criminal liability comes into action where there is, if your lordship gathers from these 3 places that prima facie there is a criminal liability and all these things, suit and everything. I am not saying that your lordship will close your lordship.
Hey, what will happen? What will happen if your 151 is dismissed?
Now, 151, even if it is dismissed also, these things will not go. But the documents are telltale. He has described in 2 places this inquiry, criminal inquiry, whether he has done it or not, will not be effaced. That's what I beg to submit. May I just place it, well, if your lordship permits me? But the way the story was told, it is not as simple as that. The simple way it was placed before your lordship, it is not as simple as that. If your lordship peruses only these 3 pages, and if your lordship permits, I can
page 50, page 58, para E.
56 to Jibo.
No, I read para E. That is how
Yes,
you are
the
bringing your
complainant
locus.
was well himself with the ancestral properties of his mother. His mother, Padanasin, being an old illiterate lady, only knowing put her signature in much difficulty, has suffered from various.
That is how you bring the locus.
Just let me clarify. This 151 petition has been entertained. It was sought to be rejected. That petition was rejected, affirmed by this honorable court. So therefore, to say that it was fraudulent has been also prima facie accepted by this honorable court. So 151 is pending.
That
so therefore,
151, the fate of the 151 application has
so that therefore I was saying, if your lordship peruses from 56 onwards, but that will connect. It is not this only paragraph E. If your lordship sees this, but rather paragraph B, C will be more important than E, because E is a consequence of para B and C.
You just tell me what is this stage of 151.
I'll find out.
Simply tell me. Then I'll decide. The argument or the party heard. Party heard. Mr. Mishra, the senior counsel, to place on record the stage of the application, status of the application moved by him under section 151 CPC, seeking the
That is CMA
consent
number
decree.
35 of
Being CA numbers? CMA number?
35 of 2011.
35 of 2011, seeking the compromise decree dated. Where is the compromise decree? Compromise decree dated
But 28/6/2007.
28/6/2007. 2007 passed by Learned Civil Judge Senior Division Bhubaneswar in CS number 825 of 2006 as a nullity being obtained by fraud. Release the matter forward. Parted. You just tell me then. The ideal thing would be, I will direct I can't direct that because you have to pursue that 151. Let us see the fate of 151.
Right.
Application.
देखिए David.
Page 22
Instruction
ରେ
name.
ପ୍ରମେୟ verification କରିଛନ୍ତି identify me Ulas Samudra age number 55 years son of late Loknath Samudra. She has put her signature page 22 ରେ ଅଛି.
Those things will be evidence.
Yes.
Those things will be evidence.
Idea is create evidence.
I'll also
here
point out
to
whether
Is there any chance of settlement?
settlement ଯାଇଥିଲା fail କଲା.
अच्छा ଯାଇଥିଲେ, okay.
The greediness to grab property is not resulting in a settlement.
The
I'm taking back that.
The thing is, the property is neither yours nor hers. It is property somebody else. Either it is Raghunath or Loknath, I don't know. You people are fighting.
Married, that will be the truth will come out.
Well, let us see. Look.
But I'm taking back that CRP order.
Yes,
But then this is how we are getting from the website. Now things have changed a lot. Now it's very organized. But this is the way we are getting. And they say download it.
Those things will be organized when you download this kind of thing used to come.
Used to come. Now it is coming in a very
systematic way. Because now it is in PDF form. Earlier it was not in PDF.
Requesting one more thing. If you already permit, this is here's the case. Now, usually the government councils have a password or code. They can download any case from the website. Your Lordship knows that. I think if it is provided to all the lawyers of the bar, because why I'm saying this is in public domain. So this is now scanned. This is now there. Any government council has access, they can get it. All my friends or seniors sitting here can get it. So
only orders.
The private councils. No, the entire brief. I'll show to your Lordship any brief they can download in full with order sheet. Whatever we are seeing here, they can get it immediately, my lord. They have a password code. Every government council. So if that is there, we all the private councils this side who are not able to go to the government side, but should also get a copy of it.
You're right.
I think this is a fair suggestion for the members of the bar. My lord, this will help in the sense why assistance will be
because
better.
now it is in public domain. All the documents.
I'll only request through your Lordship that if your Lordship can put it in the full court. This is my prayer before your Lordship.
I'll just see that. This is
I think
good idea.
But they are getting it, and I'll also.
If it is a classified document, it is for them also.
Not a classified. Why? Whenever we need a copy, in fact, we are taking help of our friends to get it. So
in any case, it is.
We are getting it. So if it is, we are getting it directly. I think there is no harm. We are officers of the court, my lord. We'll definitely uphold the sanctity of the court, my lord.
Or to maintain some discipline, the lawyers can register with the.
One thing, what will happen? We are taking now. This is there, man. We are taking help of it to see it here and all these things. If we get it directly, we put it in our tab. Also, we help it little better way. But the preparation will be little better.
No, the threat may be some piracy or something may happen.
Piracy will not
happen. Control it. Go to the entire public then.
But your Lordship, they are having the code. Your Lordship,
at least they are answerable. We don't limited access.
No, it is not like that. Your Lordship will put a.
Now we can control.
Yes.
Like advocate. Those who are advocate record, at least they can do it.
May I just point out one more thing? Previously, your Lordship was not taking all our details, buckler, tama, license number. I think initial stages of my practice.
Now it is everything.
We put everything. So anybody committing that, your Lordship can always howl him up. But if that happens, I think it will help all the.
I'll speak to CPC.
And your Lordship may also see that if they are getting it and they are maintaining that dignity of the court, I think
there must be some issue maybe. I don't know.
LMS I think.
We are not getting all the documents.
That's fine.
What it says, whatever access you people have, the other people should also have.
And even if I say
any client will get that password or something.
No, client can't pay. We are the officer of the court. Client can't pay.
We have the lawyers have to act responsible. It should not go to hands.
I don't think the state councils are responsible, and we the private councils are not.
General statement is all right, but otherwise you know that.
No, your Lordship, that may be aberrations here and there, but that will not just pollute the entire.
I'll just ask what is.
And I think there was just let me clarify one more thing without noise. There was a proposal, I guess, if I am correct, that the lawyers will be given individual code to get these things done. That will be convenient, my lord. It doesn't harm anyone, my lord. Even of the court, if I can say, we get chora copies at time. So how does it make any difference, my lord? will definitely
I'll put it in the right
uphold the
place.
dignity of the court,
You
my lord,
can
definitely.
senior counsel, it will be.
Ethere oppose
Senior counsel.
I don't
Today he is
classify
engaged,
myself.
tomorrow he may not be engaged in this matter. Why would he bother?
I classify myself as a lawyer. Senior, junior, it is
No, senior shouldn't have any access because seniors are appearing
We are- yes.
day to day basis. If they are brief, they'll come. If they
yes.
don't brief,
Rather, we cannot have access. How? ପଣ୍ଡା ଆଉ ଯଦି ଆକ୍ସେସ କରି ରଖିପାରୁଛନ୍ତି ଆମେ କରିପାରିବୁନି ଠିକ
if there is no
ଆମେ
problem,
ଏତେ ଦାୟିତ୍ୱହୀନ ଆମର
we can think of that. Now things are,
it's all broad and I know your lordship is broad minded, so I have requested you.
No, I'll just put it. I'll just see what can be done. I'll see. Entry mode to it. Yes. Huh? Actually, what? 77.
Compromise matter, my lord.
What are the offense?
Long time, 76. Right?
Arjun.
I compromise, right? I was able to,
Somebody mentioned on your behalf, madam.
beginning take off, it's 10:32.
Who mentioned?
I'm waiting for this.
75, 76,
This year.
78, 79.
76 guys are more technology.
76 Arjun. There is an Arjun.
Somebody mentioned, madam.
Arjun. Somebody.
One minute. Let me see what is 70. She has been waiting. 70? 76. Somebody mentioned, I know. You are for whom, madam? Petitioner?
No.
For petitioner, somebody mentioned some personal difficulty.
My lord, if you give me some time, I need to explain this case.
That's right, but the absence of petitioner, I can give a short date. I know 2024 petition.
24. This passing, this FIR has been pending with the IO since 2022. And this fellow, the opposite party is a lawyer practicing in Bombay High Court and Goa High Court. So she's playing a foul game and she's harassing the senior citizens. Both are senior citizens. They are in very bad condition, and their only son also suffering.
Then I'll give a short date.
Yes.
You tell me the date. Speak to our court master immediately after the bench. We'll give it. Okay. Yes, 77. I have a special bench, so I'll have to rise. So therefore, I finish the matters where. Yes.
My lord, compromise matter, my lord.
Yes.
But petitioner and victim got married. Offense under section 366, 294, 34 of IPC and 363, my lord. My lord, informant already appeared, my lord.
No, what are the allegations?
Allegation, my lord, kidnapping.
They are married.
My lord,
Have they married or what?
kidnap करके बाहर ही चल.
That's what Baha.
Rest is, your lordship may take up any day because I am not getting a single pipe.
He'll give a date so that another 7,000 will get before one day. Wait.
Pardon me,
Yes.
pardon me, mention that.
Item 80 to give a date, but he'll adjust how many matters are left.
नहीं आमर गोटे मेडिएशन को रेफर होबार
Separate bench therefore I'm good.
आमर गोटे मेडिएशन को रेफर होबार आइटम 83 83 your lordship has directed after appearance of the he is appearing.
I'll send it to
Your lordship has sent it
83 na
83
in the conjoint for the council for the party conjointly submit that there is a scope of out of court settlement in this matter. Hence, they request to refer the matter to High Court mediation center.
High Court mediation center.
High Court mediation.
Awaiting mediation reports.
One line may coordinator will intimate this the date.
Coordinator
Because
fix a date and intimate to the party.
yes.
Item 18 there is a compromise. The
18.
joint affidavit has been filed. Can we take a next?
He'll give date in every matter. He'll give it date. Don't worry. Because I have a special bench. Otherwise, I would have attended.
Beg pardon, Your Lordship. Item number 103 of the weekly list that has been many times adjourned, Your Lordship. It's a part-heard matter. Any date.
We are struggling for this belief you are talking about weekly.
My Lord, any date for final hearing in this matter. We have concluded our argument. The argument side of the.
Somebody mentioned in the morning.
Yes, my Lord. Yes.
That good.
Body. Every day he comes, he'll get the fees. What is the harm in his coming every day?
I wish he gets a fee for mentioning also. No.